good evening, everyone. Good evening, good morning, good afternoon, whatever time of day it might be for you on this lovely Tuesday. So, yep, I'm a little bit, a few minutes late, but that's not uncommon for where we are. We have a lot to talk about tonight, and I wasn't going to live stream during today. You guys know that, generally speaking, I have a full-time job, still a full-time lawyer, and I still got to do all the different things throughout the week, which is why I usually reserve everything for my Friday show. However, a lot of things happened. And because a lot of things happened, we've got to talk about it. And let's go ahead and start with some good news today. So, good news today is this. So, for those of you guys who have not been aware, there's a young YouTuber by the name of Corey who goes by Captain Corey, who has a YouTube channel, and we've been advocating for his benefit. Corey is essentially has had 2 heart transplants. Now, Corey is unfortunately terminal. And, well, he made a wish through Make-A-Wish. And as a part of that, one of his wishes was that he wanted to be a YouTuber, and he wanted his YouTube channel to get to 100,000 subscribers. And that was his final wish. So a bunch of us chipped in and we said, you know what, let's make this happen for this young man. And I've been going on about trying to get him up to 100,000. And you know what, y'all, you didn't just do it. You showed up in a force and you got us to 100,000 subscribers, 136,000. Now, for those of you who have been following on social media, The Rock has chimed in, Popcorn Planet's chimed in, Emily's chimed in, Nick's chimed in. Literally anybody and everybody that has a YouTube channel that is part of this community has chimed in to support this young man. And Johnny Depp laid down a challenge to him, rather a secondary approach, and said that he would knight Corey if we got him to 200,000. Now, my channel, we were at like 183,000. I would love nothing more than for this young man to surpass 200,000 well before I even get close to that number. So that said, if you are here for the first time and you have not yet subscribed to this young man's channel, please do so. Let's get him to 200,000. And then also let's get him that silver play button. I know that people at YouTube are already in touch with him and his family trying to get that expedited for his benefit. And we're going to go ahead and make sure we get that done. And we've got some other friends. So Ian, Runkle of the Bailey, who I often have on my channel, is making him a leather play button. I am making him a wooden play button. I've also laid down a challenge to different makers to try to make a play button or something to show this young man some love, because I want to see the unboxing. And he's already said that he will be doing the unboxing of the various things that are sent his way. I know that Steph, the Alter Nerd, who appears regularly on Popcorn Planet, is in contact with the family. They have a P.O. box that is set up, and it's being set up, and we're going to have the address to mail these lovely items within the next few days. So keep an eye on social media for that. We will try to update you guys as soon as we can. But right now, 136,000 subscribers. Let's see if we can get to 200,000 and see if we can't get him a bunch of play buttons for this lovely young man. So while that is going on, we also had some interesting developments in the regular world when it came to one of my favorite topics, Mr. Samuel Bankman-Fried, formerly the CEO of FTX. For those of you who are unaware of who FTX or who SBF is, Sam Bankman-Fried was the CEO and owner of FTX, a crypto exchange currency, which had about 134, I think last count was 130 something entities under its umbrella. And well, we're getting into that, those specifics in just a minute. I also wanted to draw attention to another YouTube channel that someone pointed me to, because this channel, and I like to highlight small creators and creators when they are coming up. In fact, I was a small creator just a few months ago, and well, enough of you guys are here that I kind of want to see if I can't pass that along. So that said, what I also want to do is highlight this man here, Mr. Moffat on Money. Now you can see he's got 35 subscribers. Now, when someone tagged me in this, I was kind of surprised. I was going, well, you know what? I have a pretty good understanding of this case. So I went and watched the video, and his little video breaking down Samuel Bankman-Fried and FTX was actually pretty remarkable. He does a very good job of relaying the background of this entity and the enterprise and crypto in general, just how we understand this. So if you wouldn't mind, while you're on YouTube and subscribing to Mr. Captain Corey and cracking the box, I would like for you to also take a look at Mr. Moffat here, because like I said, he does a great job explaining this entire background and does a great basic level understanding in layman's terms, how we can understand crypto and how we can understand how this, well, scheme really was played out. So again, that's Moffat on Money. Here's his channel. Moffat on Money 7966. Looks like he's up to 51 subscribers. That was probably you guys right now. But yeah, so let's go ahead and see if we can't show some love that way, because he does a great job of breaking things down for us to understand. So that said, let's get into it. We have a lot to cover here. We have a bunch. So let's start with this. What is FTX? What is crypto? Well, best way that I could think of to explain this and the theory of how crypto works is crypto is an asset, not really dissimilar from a lot of other assets. And I was walking around the house and I found this thing. $1. How much is this worth? Well, you guys say it's worth $1. $1's worth $1. But how much is $1 worth internationally? How much is $1? How much is this piece of paper actually worth? Well, it's worth what people will pay for it. How do we know what people are going to pay for it? Well, every single currency is backed by the full faith and credit of the government that provides it or produces it. Now, this is going to become relevant in a second. So the US dollar is essentially backed by the US government. So people trust it. They understand that this currency is something that we should trust. We should be able to exchange on it because the US government uses it as its currency. How do we verify that? Well, the dollar is also traded. People trade based on the value of the dollar on various markets. So the dollar is pegged at essentially what people will buy, what people will pay for it. That's how we price these things. So I want you to look at crypto when we talk about these things in a similar fashion. Think of these crypto, well, money makers, the people that actually make the market makers. Think of them as little baby governments. They're baby governments that create a currency. They create something like this, $1. What's it worth? How do we know what it's worth? Well, the first thing we have is we have what the government says it is. We have what the exchange or what the market maker says it is. The market maker says it's worth a certain thing, $1. So you have a tangible currency, something that's crypto. It does exist. It is an asset. What's it worth? Well, you've got the market maker who says this one crypto token is worth this thing, equal to this thing, this $1. Well, that gets verified. How does that get verified? It gets verified on markets and exchanges, because you can make a promise that $1 is worth $1, but then does that promise hold up? What are people willing to pay for it? Are people willing to buy and sell that $1 at that rate? And this becomes relevant when we start talking about FTX, because FTX created its own dollar, FTT. And what we're going to start seeing when we look through some of these documents is that they might have overinflated the value of FTT. And in doing that, they leveraged against it. They basically created a hypothetical dollar, and they said it's worth this, and they borrowed money based on that promise. And when they borrowed that money, and they traded on it. So they took the hypothetical dollar, they used that to value their asset, and then they traded based off of it and took your money based on those promises. And they used that money for their own purposes. So how does Samuel Bankman-Fried play into all of this? Well, Mr. Bankman-Fried was the owner of FTX. A young man who, well, didn't really appear like we would think most financial planners or most financial advisors to appear. He wore shorts and a t-shirt, had curly hair, and was really kind of, for lack of a better word, kind of a hipster in how he spoke. He spoke about effective altruism and taking money and being able to, well, raise money, not for any personal gain, but for the gains of society, for better good. And you'll forgive me, but this is a wine drinking live stream. Because, oh my word, did things go sideways. They went sideways in such a fashion that Mr. Bankman-Fried has finally been arrested and charged in the Bahamas and charged simultaneously in the United States in the Southern District of New York. And we'll walk through those charging documents. So let's do a 5-minute overview of where we are and how we got there. And then we'll get into the charging documents. And by 5 minutes, who the heck knows what 5 minutes is going to be. So Samuel Bankman-Fried owns this exchange. And the exchange was, it was the bee's knees. It was the talk of the town. Everyone loved it. Everyone trusted Samuel Bankman-Fried. Now, why did we trust this guy? Why did we trust him? Why did everyone trust him? Well, because he said the right things and he did the right things that made us think that he was alternative theory. He was new theory. He was the way that these things were supposed to be and how they were supposed to go and the way that we were supposed to progress forward. Companies didn't exist for the benefit of shareholders or stockholders. Companies existed for the benefit of everybody. What he ends up doing is he ends up taking people's money and he spends it around for his own purposes. And he also made a lot of promises that he never really intended to keep. Promises that he would donate a certain percentage of all FTX's value, 1%. Well, he never really donated jack. Well, it's kind of not really true. He did donate to some pretty high hitters in Washington to try and keep him safe. He donated to certain people to try and pump up the value of his company because he understood that there was a social value to these things. Now, when I say he understood there's a social value to these things, I'm not trying to say that social value is really anything. But what he did was he capitalized on individuals' views and perceptions of companies and of people in general. FTX would go and basically invest in different things. They had a Super Bowl commercial for several $1 million. I think 30 million was the dollar figure, where they basically said this is a safe place to invest. He went out and got other trusted individuals such as Kevin O'Leary from Shark Tank, Stephen Curry from the Golden State Warriors, Miami Heat. He put his name on the basketball. He put FTX's name on the arena. And that's part of the bankruptcy case we'll get to in a minute. And he basically went and hired these people to go out and say, look at this company. This company should have an inherent value. And he traded and opportunized. Is that a word? Gained remarkable opportunity off of these promises from third parties. That brings in a different person. Mr. Moffat, I see you in the chat, buddy. Thank you very much for the super chat. You didn't have to do that at all. But yes, I did want to highlight. I love the content. I love the video. It was a great walkthrough, very great walkthrough at a very basic level that gives people a very good understanding of how these exchanges work, how these things are supposed to actually function, and why the red flags were blaring when it came to Sam Bankman-Fried and FTX from the very beginning that people just simply ignored. We don't have to ignore them anymore because now we have charging documents. So, getting us to today, Samuel Bankman-Fried has been rather vocal on Twitter ever since the downfall or the viewed or perceived downfall of FTX. He went out on Twitter and made promises that there was nothing was a problem. The sky was not falling. Everything is fine while the world is caving in around him. Now, Mr. Moffat from Moffat on Money, I like what he said. He said that basically when the guy's out in the street saying, everything is fine. That's a good sign for you to take your money and run because it ain't fine. So let's go through some of the additional background. So Twitter was Samuel Bankman-Fried's Achilles heel. Let's rephrase it. It wasn't really Twitter that was his Achilles heel. It was him. It was how he viewed everything. It was how he perceived everything. It was what he was trying to sell people along the way. Now, he was supposed to testify before the House Committee on Financial Services today, chaired by Maxine Waters, a relatively large committee within the House. He was supposed to testify before them today, and a lot of people are very disappointed that he didn't testify. They're viewing this as basically saying Congress would have done something. Nope. If anyone has ever watched or had seen him speak in any of these Twitter spaces, he talks in circles. He never really answers the question. I was rather strong in my admonition that he shouldn't be talking at all, but then when I realized what he was saying, I realized he wasn't really saying very much of anything. Now, he did get to a lot of admissions, mostly at the hands of some very, very clever YouTubers and very clever people that follow this stuff on Twitter. I will say that Twitter and the on-the-ground civilian reporters on this case have been miles ahead of corporate media, miles and miles ahead of corporate media. One of the largest channels, CoffeeZilla, coffee break _ UYT on Twitter, has been really vocal in his criticisms of Sam Bankman-Fried, and justifiably so. Some of the most fun exchanges to watch were between CoffeeZilla and Sam Bankman-Fried during these Twitter spaces, when CoffeeZilla would kind of, I don't mean to say negatively, but ambush him with questions and kind of catch him off guard. I like the tactic. It was done very well. But Sam would admit, after serious questioning, to such things as commingling funds. Big, big no-no. Can't commingle. Very bad. And Sam always thought he was the smartest person in the room. And I don't think Congress would have gotten a single thing out of him based largely on how that hearing proceeded today. You had congressmen basically cracking jokes that they wanted to call it. I think it was a doo-doo coin or something dumb like that. Someone said it was doggy coin instead of Dogecoin. I don't know how they vet these people for their understanding. It's really kind of ridiculous. It's kind of humorous. So let's actually take a look at what Sam Bankman-Fried would have testified to had he been present at Congress today, because that was the funniest part. During part of this hearing, after Mr. John J. Ray, who gives his opening statements, who is the replacement CEO, we'll get to him in a minute too. After he goes through, we start to get the questions part of it, and one of the congressmen says, we can't even read what he would have testified to in front of this committee. We can't even read it publicly. And I went nuts. I was going, I got to find this. I have to find what he was going to say. Again, Twitter to the rescue. Someone sent it to me, and Forbes had basically gotten their hands on it beforehand. So let's take a look at what he would have testified to. Ooh, baby. Y'all ready for this one? Let's go ahead and walk through what his testimony would have been today. Pull up the things. Can I do this? I can. This is the written statement that was given to the House Financial Services Committee prior to the hearing. Now, this is something that people don't oftentimes know. When you see congressmen getting their sound bites, congresswomen getting their sound bites on TV, they have an unfair advantage. Every single witness that appears before a committee is required to produce and provide written testimony ahead of time, so the committee members have a little bit of advance notice of what they're going to testify to. Not really fair when you see them, the congressman, grandstand based on what they've already seen is going to be testified to. It's lovely. So, lordy. And I had the assistance of a new friend, this guy. Thanks to Law Talk with Mike and those of you in the chat that watched me on Friday Night Frenzy, because we now have a new bleep button. And the bleep button is, yeah, I now have a screaming unicorn. So thanks, guys. Anyways, here we go. Summary. This is Sam Bankman-Fried speaking. I would like to start by formally stating under oath, Let me say it again for the people in the back. I know that it doesn't mean much to say that I'm sorry, and I'm dedicating as much of myself as I can to doing right by customers. Bullshit. When all is said and done, I'll judge myself primarily on a metric, whether I've eventually been able to make customers whole. If I fail our customers in this regard, I have failed myself. It's an inherently narcissistic comment right there by itself. Last year, my net worth was $20 billion. Maybe when you're facing the committee after the downfall and collapse of your enterprise, and after millions upon millions in the billions have been lost of customer money, maybe you shouldn't go out leading with, I was worth this amount of money last year. Just saying. Anyways, proceeding. Today, I would be wrong to say that I have nothing. I have a loving family and food on my plate, and that's more than life has given billions of people. You mean like the millions who lost a lot betting and investing on a asset that you told them was worth something? Just saying. But last I saw, I believe my bank account had about $100,000 in it. I don't know for sure because I've been denied access to many of my own personal passwords, data, documents, and accounts. If you were denied access to those, it's because they were in the bankruptcy case, which means they weren't personal, they were FTX. But that also gives me an impression of how you managed FTX and how you viewed things that were owned by FTX as being yours. As of today, I and many other members of FTX's international former management team are missing access to key data that could help inform customers, inform the Chapter 11's team's decisions, and inform foreign regulators looking after FTX International. Now, we're going to see a lot of focus on FTX International because he really doesn't want to be in this bankruptcy case. Nearly all of this data has been held by the Chapter 11 team. That's what happens when you file a bankruptcy. The trustee steps in and owns all your shit. That's just what happens. In fact, many of us are still missing access to our own personal data, which is being held hostage by the Chapter 11's team's leadership. Again, misunderstanding of bankruptcy here. When we have asked for access to our personal data and passwords, an example response reads, quote, "You should take steps, as we've suggested to others in the same position, to reset two-factor authentication passwords for any relevant personal accounts." As such, much of my testimony is less confident and detailed than I would want it to be, and I apologize if I am unable to confidently answer completely reasonable questions. This is the same song and dance he's been doing in the Twitter spaces all freaking week and all of last week. I can't really answer all the questions because I don't have data. Well, dude, you are the 90% owner of FTX. You should have the answers. I unfortunately cannot access most of FTX's current or historical data right now in order to explore or confirm my understanding. Interlude, appropriately so, because when you had access to the FTX accounts, ledgers, and information, you didn't do good things with them. I also cannot access most of my own notes, writings, spreadsheets, data, or email because they're property of FTX. They're property of the enterprise and the company that's in bankruptcy, and you don't own them anymore. They're company property. Mr. Ray's team has even refused to return to me my credentials for purely personal accounts. I wonder what those are, Mr. Bankman-Fried. I deeply regret giving into the pressure to sign forms that precipitated the Chapter 11 filing just a few days after FTX International became potentially insolvent. FTX International became potentially insolvent. Again, the focus on FTX International. Among other things, the Chapter 11 team was thrust into a very difficult situation, and I worry that they were given very misleading information by a few members of the FTX US team when they joined. They are trying to manage multiple complex global entities and systems without support from many of the teams who used to run them. I believe it will be extremely hard, if not impossible, for the Chapter 11 team to move forward constructively without working cooperatively with the many foreign jurisdictions that have direct regulatory and operational control over FTX International and its subsidiaries. Here's the scheme. Well, part of it. This company was structured in such a way that it operated through various shell corporations that were incorporated in the Bahamas and other entities or other jurisdictions. I think Hong Kong, Japan, China, Bahamas. I forget where else. I feel like there were some in the Eastern European countries as well. In any event, this is a very clever scheme of creating multiple shell corporations that exist under jurisdictions and laws outside of the United States, so that in the eventuality of a corporate bankruptcy filing within the United States, there would be a challenge in bringing all of these under one roof. So, Mr. Bankman-Fried, the assertion that the Chapter 11 team is going to struggle without your involvement, I think they would have struggled either way. And right now, probably best that they are. I have offered many times. I've offered many times to help the Chapter 11 team. To cite just one example, I would have been able to easily collect some pieces of data they expressed an inability to find in their court filings. I have not received responses to those offers or to any other messages I have sent them. Yep. I've reached out to Mr. Ray and the Chapter 11 team numerous times. Sometimes I've been requesting access to my own data, but other times I've been attempting to alert them to potentially important information for their jobs and duties to be creditors and customers of FTX. I see how you went back to FTX generally there, not FTX International, FTX US, but FTX as a whole. Interesting. I've sent 5 emails to Mr. Ray. Mr. Ray has never responded, nor has he reached out to me to communicate in any other ways. He has not responded, for instance, to an email of mine that stated I have potentially pertinent information concerning future opportunities and financing for FTX and its creditors. Hold up. Wait. Hold up. I have potentially pertinent information concerning future opportunities and financing for FTX and its creditors. Mr. Bankman-Fried, you are trying to sell something, a future financial opportunity. Well, why should we trust you? Why should anyone trust you? Why should you be trusted in any regard to offer advice for future financial opportunities? What, so that we can continue to launder money? Sorry, that was kind of a hot take, but hey, you know what? It's not that hot of a take given the the filings. We'll get to the filings in a minute. I also believe that I have relevant financial information about FTX US, and further, that I have potentially relevant regulatory information concerning FTX. I would love to talk to you, whether it's via email or phone, and to work constructively with you and the Chapter 11 team to do what's best for customers. His version of working constructively with you and the Chapter 11 team to do what's best for customers includes a filing in the Southern District for New York, a competing bankruptcy filing asserting that the U.S. bankruptcy courts did not have jurisdiction, and that instead Bahamian bankruptcy courts were the only jurisdiction that could actually go through this liquidation. So I doubt that you actually wished to work constructively with the Chapter 11 team. I think you just wanted to get out of bankruptcy because you thought you had money through other financial schemes, again, my opinion, to basically bring FTX to a appearance of solvency on the books, which, as we know, given the bankruptcy filing, was just an appearance. It was a shiny thing that you sold people. To the best of my knowledge, FTX US has been and remains solvent and could pay off all of its customers in full tomorrow. Okay. Unfortunately, the Chapter 11 team has frozen the FTX US exchange, blocking customers' access to their account information and funds. Oh, look at you, you bad, naughty Chapter 11 team. You did bad. You did bad. You blocked access and data. You guys bad. Chapter 11 team bad. No, the data that they were looking at wasn't really real. The customers who have lost assets are those who traded on the FTX international platforms, which do not accept U.S. residents. Emphasis added in italics, which do not accept U.S. residents. You're really holding this jurisdictional argument, aren't you? My primary focus right now is to do right by the customers of FTX International who were hurt. I'm fighting to make these customers as whole as I can, and I will keep doing so as long as I see any pathway forward, because that is my duty. Sir, you don't have any more duty. You don't have a duty anymore. You're not CEO. I believe that there's a credible path forward that will put together billions of dollars of additional funds for FTX International customers. That would involve significant external financing, which in turn, I believe, would require the FTX exchange to restart operations. Wait a second. Wait, whoa. This is your testimony. This is your testimony. This is what you wanted Congress to do. This is what you want the Chapter 11 team to do. It would involve significant external financing, which in turn, I believe, would require the FTX exchange to restart operations. You want us to give you the keys back. You want the keys back. You drove the company into a tree, completely destroyed it, and you want the keys back to try and keep driving it home. Sir, you were drunk at the wheel. You drove off the road. A cop catches you. You say, "No, officer, I'm okay. I'd like to continue driving home." Not how that works. Doing so will be significantly easier if the Chapter 11 team worked cooperatively with the foreign jurisdictions, there's that word again, that have regulatory authority over FTX International and its subsidiaries. Ooh, baby, you really are holding to this. I have heard complaints that the Chapter 11 team is refusing to respond to regulatory inquiries from foreign regulators, sometimes at the risk of employees going to jail. Okay. I've also heard complaints of the Chapter 11 team freezing or otherwise interfering with funds duly belonging to the various operating entities of FTX International. I hope that this is greatly exaggerated, or at least that it was a product of an initially unfamiliarity with the company and the industry that has now passed. It has been a month since the Chapter 11 filing, and the password to my LinkedIn account hasn't been returned, though I'm not overly optimistic. Bro, you're worried about your LinkedIn password. Hang on. Wait, so let me get the crux of this. Yes, I drove the company off the road. I want the keys back. Please give me the keys back. Also, I've been very greatly harmed because I don't have my LinkedIn password. Anyone else? Anyone else? No, just me? Just me? Okay. I have a duty towards the colleagues and supporters who fought for FTX day after day and who were deeply hurt by a collapse that they didn't bear any responsibility for. These people that were also at the helm of FTX, employees of FTX, who were also allegedly knowing what was going on, you're worried about them because they no longer get to live in the $121 million of real estate that FTX had purchased. Maybe. But no worries. What happened? Well, I'm not really going to take your word for it. But let's go ahead and read through. The reconstruction of events concerning FTX International, a non-U.S. crypto exchange for non-Americans, run out of the Bahamas and not regulated in the U.S. Do you guys, oh my gosh, do you happen to see? Look at all of this. Look at this. Reconstruction of events concerning FTX International, non-U.S. crypto exchange for non-Americans, run out of the Bahamas and not regulated by the U.S. And you were going to say this to the House Financial Services Committee. Whew. To my knowledge, FTX US, a separate US-based exchange that does accept Americans, is fully solvent, and thus all US customers could and should be made whole immediately. I wish that I could give a fuller account of what happened. Unfortunately, I don't have access to much of the relevant data right now. Here's a reconstruction of events to the best of my recollection. I apologize. I do read a little bit fast. So for those of you trying to catch up on 2x, get ready for the speed squirrel voice. It's going to happen. I started Alameda Research, a private crypto trading firm, in 2017. Please admit to me how you started a company that actually ends up being the crux of much of the argument for your now incarceration. I started FTX International, a non-U.S. crypto exchange for non-Americans, in 2019. I began transitioning away from an active role in Alameda Research then. Okay. Started FTX US, a U.S. crypto exchange that does accept Americans, in 2020. In reconstructing the events of 2021 and 2022, I am relying on memory and extrapolations, as I was not fully aware of many of the critical events at the time they happened and don't have access to the relevant data right now that will allow me to confirm or disconfirm my best guess at this point. In particular, I was not running Alameda Research this past year. This is so infuriating, and we have so much to get through, so we're not going to get through all the testimony. I apologize in advance. The reason why I apologize in advance, because a lot of this is complete and utter bullshit. A lot of this is the same stuff he's been saying on Twitter Spaces, left, right, and center. It is a 3,000 foot up view down of a picture that he is trying to paint. He doesn't give any real answers. He dodges every single question, and he tries to deflect wherever he can. Good luck to the attorney that gets to cross-examine him. Ooh, you know what? If you want to trade, I will check in. I'd be happy to. This was a lot of fun. There we go. FTX was licensed and regulated to operate by regulators globally, including the Bahamas, Switzerland, Japan, Australia, Cyprus, and Dubai. Holy smokes. Do you guys see the entities and the governments that he sought to be regulated by? Namely, those entities that are famous and infamous for their absence of certain regulations. The Bahamas, Switzerland, Cyprus, Dubai. Dude, you hit four of the nations that, historically speaking, don't really give a lot of their information away or allow their information to be given to regulators for very, very specific reasons, and where people like to put money that they don't want discovered. So please tell us why we should trust you and just turn everything back over to you. Please continue to tell us that that's what you want. In late 2021, I believe that Alameda Research had a net asset value of substantially $50 billion market to market. Remember that little thing I told you about? This, how we value these based on the promise made by the government that backs it, and based on how it's tested across different enterprises and across different exchanges. Well, here's the thing. FTX printed FTT. That was their currency. And FTT, their currency, was not traded on other exchanges. So his valuation for these things is pegged at what? Hypotheticals. Leveraged valuations, basically. He would borrow money against, oh, okay, we're going to get, keep going, Rob. Check out Moffat. He does a great job on this stuff. In early November of 2022, over a 3-day period, the market value of assets that Alameda Research had declined dramatically, I believe, by more than 50%, because people discovered the valuation was overinflated. That's how that drop happens that fast. That is how that drop happens that fast. When people discover that you have overinflated a value of the asset that you have been selling them, the market adjusts. And when it adjusts in very drastic fashion. So this is probably market adjustment. After that crash, Alameda had, to my knowledge, roughly 11 billion of assets and roughly 11 billion of liabilities, market to market. This little caveat, market to market, that's based on his analysis and only his analysis. That's not verified. That's just his assessment or opinion, including its position on FTX. However, many of the assets were not very liquid and could not be quickly sold. I believe that roughly 3 billion of the assets were highly liquid, leaving a liquidity shortfall of roughly 8 billion. That's what he said he had investments to basically do. Run on the bank. This is basically everything that led up to the bankruptcy filing. Binance's CEO basically discovering that the entire thing was propped up on a house of cards and saying, I want out, tweeting and basically saying peace out, that resulted in that lovely fast market adjustment and the extreme pressure on FTX that then required/forced him to consider filing bankruptcy. What went wrong? Well, I'm not going to trust your opinion on it, because I'm going to go back to the actual filings in the various courts, because, hey, you know what? A lot of those are verified. Stuff changed. I want to get to the one part of this testimony that I think is kind of interesting, because he starts throwing some real shade at the Chapter 11 CEO. Excuse me, little frog in the throat. I deeply regret what happened, and I would give anything to be able to go back and put in place the detailed oversight and risk management I should have. Based on my reading of all of this, I think that two parts of this are true. I deeply regret what happened. I deeply regret that my company failed and that the market called me out for overinflating the valuation of the company. I would give anything to go back. Those are the things that I think that he actually says here that are truthful. This part, that's for the benefit of Congress. That's for the benefit of the members of Congress that he was trying to sell this new thing to. Right now, I'm focusing on what I can do to make customers whole and reflecting on what I did wrong. There are more things I wish I had done. So this is where he says what he did wrong. This is a good one. I wish I had operated FTX International, there's that word again, with a consistently high degree of transparency to myself and our employees and customers and regulators. We were transparent about market data and access and fees and many other things. These are things he wishes. We were not transparent even internally, even to ourselves, about assets and margin and positions and risk. You mean when you were spending money that you didn't own and buying houses and property? That's what you're talking about, not being transparent. I wish that I had ensured we built our public monitors that displayed 1, total client balances, 2, total blockchain balances and the corresponding addresses, 3, total bank and fiat balances that were in FTX's name, 4, total bank and fiat balances that were in a payment processor's name, 5, total margin position and total futures position size and the amount and types of collateral that were utilized to support these, 6, the treatment of margin and risk on all accounts. BT dub. Points 1 through 6 of these things should be in place before you ever create an exchange or before you ever create something of this type of financial enterprise. Regardless of the size, points 1 through 6 must exist before the company exists that does those things. I wish that I had deployed public API endpoints to pull the above data. I wish there was actually, that's basically him saying, I wish that people could see what I didn't want them to see. Private API endpoints that served anonymizing versions of account balances and risk to regulators for oversight. Now you want the oversight. Cute. Very cute. Very, very cute. Ooh. Ooh. I wish that when cracks began to show, I had communicated openly with our employees, users, and community rather than freezing up and remaining mostly quiet per lawyers' instructions. Holy crap. Ho, 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 ho. We have stumbled across something here, folks. I wish that when cracks began to show, I had communicated openly with our employees, users, and communities rather than freezing up and remaining mostly quiet per lawyers' instructions as people wondered what was happening. You, sir. Oh, the audacity. You, sir. You did nothing of that. You did not stay quiet. You didn't stay quiet at all. You went on Twitter and said everything and anything that was on your mind. It didn't matter whether it was smart, whether it was stupid. It didn't matter. You weren't listening to your lawyers. Are you kidding me? The only thing you listened to your lawyers about was filing Chapter 11. And then you realized maybe I shouldn't have done that thing because now I'm going to get caught. And then you went on Twitter and went nuts. Nuts. Holy smokes. You literally went on Twitter and said everything is fine. There's no liquidity problem. You went on Twitter and said, we don't invest customer money. You went on Twitter and said, nothing is commingled. You went on Twitter and said, what? And then a day and a half later said, HAPPENED. You did not. You did not listen to your attorneys. You went on Twitter Spaces and did interview after interview. You went on you did a New York Times summit where you basically talked to the public, which asked you really crappy questions, by the way. Those interviewers who basically bought your bullshit hook, line, and sinker, including George Stephanopoulos, who did push back. I have to admit, Stephanopoulos pushed back. But it wasn't until you started going on Twitter Spaces that you actually started getting called out. And then you started really abruptly ending those conversations very abruptly, especially when CoffeeZilla or someone started being a little bit confrontational with you. I think at one point in time, in the most recent one, Caspian C is what it's supposed to be. Caspiancy in the unusual whales Twitter space calls him out, starts getting aggressive, and he's like, well, are you going to ask a question? You did not listen to a single thing your lawyers told you. Mark Cohen, who you hired, who represented you today in your Bahamian bankruptcy case or your Bahamian criminal case, Mark Cohen, there is no way that Mark Cohen said, you know what, Sam, I've got a great idea. Here's my great idea. Mark Cohen, defense attorney who represented Ghislaine Maxwell. You know what, Sam, I've got a wonderful idea. What's your idea, Sam? What's your idea, Mark? I wonder what your idea is. Well, Sam, I think that you could probably explain away all of these charges if you just went out and you told people honestly, in response to various questions by people of the public, interviewers, people that were heavily invested in crypto and people who know crypto backwards and forwards, I think you could really, really help your case by going out and explaining to them exactly what you did. Well, Mark, I want to be very clear with you here. You're my attorney. Are you really saying that I should go out there and explain why I did the things that I did in an open forum with open questions? Without any cutoff point where I would have to flee in that moment and where I could look and be perceived as being evasive or dismissive or arrogant? Well, yes, Sam, I do believe that that's exactly what you should do. That is exactly how you should go about this. Twitter Spaces, that's where you'll win them over. That's where you'll be able to meet the people. That one, and also that whole Twitter exchange you had with Maxine Waters, accept the House's invitation. And before you do that, go ahead and prepare this entire bit of testimony. Don't worry, I don't need to proofread it. I do not need to proofread it. I trust you, Sam, emphatically. You go out there and you basically create that testimony and you send it to the committee. And I don't need to proofread it. I'll just be there picking the baggage up in the end. Of all of these things, I think that's probably the most clearly discernible lie. Of everything he's saying, it's the lie basically saying, cool, my lawyer was the one that told me I should go do this. Every lawyer watching you on Twitter was going, please, God, stop talking. Oh, it took everything in everyone's power to basically say, just, you, sir, you are something else. I wish I had not clicked a button on DocuSign at 4:30 a.m., leaving some of FTX under destructive leadership. And I deeply regret not taking the advice of employees and supporters who knew that Chapter 11 would mean for customers. I received a call from a regulatory experienced advisor who I deeply trust and respect shortly before 4:30 a.m., imploring me not to do it. I really wonder who this person is, and I imagine that someone's going to be asking that question of Mr. Bankman-Fried. Because here's the funny thing about this. Advice of employees and supporters who knew what it would mean for customers. I received a call from a regulatory experienced advisor who I deeply trust and respect shortly before 4:30 a.m. Reminder, one of the things that one of these investigative reporters was able to acquire in the way of information, and I'm going to pull up the tweet because I got to see this thing. Holy smokes. I'm going to use this opportunity to also calm down just a moment, Rob. Jeez, you don't have to be this dramatic because your head's going to explode. Genevieve Roche Decter, CFA, GR Decter on Twitter, did an interview with Sam a while back. And one of the things that she discovered in her interview, and I can't find a tweet at this moment, was that essentially on November 11th or November 10th, when was this thing? Here we go. Dun, dun, dun. Where are you? And I apologize because I did not read that part of that freaking testimony. Oh my gosh, what the heck is going on? Why is my brain blowing its gasket at the moment? Because, well, reasons. Things. I'm not going to find this thing right now. Please tell me I can find this thing. Come on. Twitter, that's the one bad thing about Twitter. You got to scroll and scroll and scroll and scroll. All the things are happening today, and we have not even gotten to the arrest yet because things happen, and things do happen this way all the time. Okay. We're still lurking and we're looking, and I'm going to be there in 2 seconds, I promise you, because I have scrolled quite a bit. Anyways, basically he admits that on November 10th, even he and his father, so November 10th, the bankruptcy was filed on the 11th or 12th. November 10th, he's in conversation with his dad, and his dad is basically telling him that both of them recognize that there are serious problems with FTX and liquidity issues. His dad, who lives in the Bahamas, his dad, who was a professor of law at Stanford, who was considered one of the preeminent authorities on tax law and regulation in the entire country. A regulatory experienced advisor who I deeply trust and respect. Oh, also his mom was a Stanford professor and also was very highly knowledgeable in all of these different transactions. So I'm very curious as to which one of these regulatory experienced advisors spoke to him shortly before 4:30 a.m. and told him not to file bankruptcy. Maybe they had a vested interest in him not going to jail. Maybe they had a personal interest in him not going to jail or being discovered for all of this stuff. Who knows? What they said felt correct to me. I talked with my counselor who strongly pushed back. In retrospect, I can confidently say that they were right and my now ex-counselor was wrong. And more than anything else, I wish I had remained grounded. Let me insert my own caveat here. And more than anything else, I wish I had remained grounded. Rob caveat. And not spent $121 million on real estate and purchased a $16.4 million home in my parents' name that is titled in their name to this day, and basically spent money buying all of the lovely things, including basically a de facto Uber service in the Bahamas for all of the employees of FTX, and lived in the house together and spent money like it was candy. I wish I had not done all of these things and just remained grounded and spent at least as much time focusing on and safeguarding user assets and risk as I did on branding and partnerships. It's that part, the branding and partnerships. That was your focus the entire time. When I was on Twitter this morning and I had read some of this testimony and I was like, there are no words, because there are no words. There is the whole listening to lawyers thing. What lawyer in their right mind would allow you to write this a testimony and say it under oath in front of Congress? Oh my gosh, this is not lawful law. This is nothing. This is just, there's nothing. There's no words. Branding and partnerships. Branding like the millions of dollars you spent to have FTX put on the Miami Heat basketball arena. By the way, the city of Miami-Dade has respectfully asked to be removed from the bankruptcy proceedings and terminate the contract with FTX so that they can resume rebranding that very same basketball arena. Like approaching Taylor Swift and offering her $100 million to please go out and promote my company. Like Tom Brady taking a flamethrower to an ice cube that was hiding FTX. Very symbolic, by the way, the flamethrower burning FTX. Like Kevin O'Leary, who came out and said that I truly believe this young man, and Kevin O'Leary, who received $15 to $18 million to go out and advertise on behalf of FTX. Oh my. I wish I had done things properly rather than going out and getting them to prop up this company. I am very, very sad for you, Mr. Bankman-Fried. Chapter 11. Between November 6th and November 10th, I received a large number of calls from prospective investors, many of them potentially interested in contributing more than $1 billion of financing. You mean so that they might get their money out before the whole thing collapsed? Because that's the funny thing about this. He keeps saying that there was a sudden influx of liquidity, that there was liquidity on the table. Well, you know what happens to companies when they're about to go under? People love to give money to it so that they can pull their money out first, so the scheme can exist just a little bit longer before their money is placed at additional risk. Shocker. I know. It's really shocking that liquidity would show up right there at the bankruptcy filing when they realized their money was at risk and their money would be tied up in bankruptcy proceedings for years. Sure. Together, there was substantially more strong interest than what it would have taken to make all customers immediately whole. For some reason, I doubt that you would have done that with the liquidity. If they had put money in, what are the bets? What are the bets? Do we think that if he had that liquidity inserted into the company, if he had that $8 billion inserted into the company, do we think that immediately he would have taken corrective action? Oh, I'm going to do this. Let's see. This is going to be for fun because I kind of realize what the chat's going to say in this particular moment. And I don't really care because we're going to do a poll. Let's see. If 8 billion became available to FTX prior to bankruptcy, what would have happened? Answer 1. SBF takes corrective action. Option 2, SBF uses money for self. Why do I feel like that's going to be a slanted poll? Because it's going to be a slanted poll. And before I forget, I do want to call out Cindy T. Thank you for the gifted memberships. And Viking Wolf by Blood, thank you for the gifted memberships, because I popped over to drop that poll and I could see that it was there. Starting on November 8th, I was put under extreme pressure to file for Chapter 11. Much of that pressure came from Ryan Miller, the general counsel of FTX US, and former partner at Sullivan Cromwell and Sullivan Cromwell itself, because he's a lawyer and because he knows what's happening. That's why. Sullivan & Cromwell was one of the primary external law firms that represented FTX US as well as FTX International at the time. I have 19 pages of screenshots of Sullivan & Cromwell, Mr. Miller, and others, and I being influenced by them, all sent over a 2-day period, pressuring me to quickly file for Chapter 11. They ranged from adamant to mentally unbalanced. They also called many of my friends, coworkers, and family members, pressuring them to pressure me to file, some of whom were emotionally damaged by the pressure. Some of them came to me crying. That is exactly what happens when a lawyer, why can't I see this? When a lawyer basically discovers that their client is doing all types of misdeeds or maldeeds or all these other things. Why didn't the poll go? To bankruptcy. There we go. Here's the poll. Okay. Anyone who's ever been a lawyer or been in a position of offering advice that is legal counsel, you oftentimes realize that your client is, they are just dooming themselves to basically go down swinging. And yes, as a lawyer, you sometimes have screaming matches with your client, basically saying, do not do the stupid thing. Do not do the stupid thing. Yes, you text your client, you call your client, you ask them to reconsider, you pressure them, you say, look, if you don't do this thing that I am telling you is the smart thing, bad things are going to happen. That's their job. Their job is to protect you. And when you don't do those things, they oftentimes become emotionally strained. That's why lawyers have gray hair, because our clients. That's why we have gray hair. Oh, yeah. No. And this also is why I know that you're not listening to your lawyers, because your lawyers never would have let you write this down. Because you know what? You know how you waive attorney-client privilege? You discuss what was communicated with your lawyers. You idiot. The ramifications of putting this into testimony might extend well beyond this. You, sir, may have, by alluding to conversations that you had with your attorney, you may have opened up a door and an argument that would not have otherwise existed, that might possibly allow for someone to say, I wonder what those exchanges actually say. And he seems to suggest what they say. Is that a waiver of attorney-client privilege? Because Sullivan and Cromwell chose John Ray to run the Chapter 11 team. I would have. The dude restructured Enron. During the time I was pressured to file, Sullivan Cromwell lawyers told my counsel that I would get to choose the board chair. They were lying. There's no way. Either that or you're just misstating what they told you. Period. Sullivan Cromwell silently reneged on that a few days later. I have no idea why that's true. I very much doubt that. Also, at roughly 4:30 a.m. on November 10th, against my better judgment, I clicked on a DocuSign link that would nominate John Ray as the CEO of various entities. Various as in almost all. Various as in like 100 and some odd entities. Yeah, you did that. Less than 10 minutes later, I received the potential funding offer for millions of dollars to help make customers whole. Don't file bankruptcy. Let me get my money out. Don't let this thing collapse just yet. Yeah, you were getting billions offered to you. A few minutes thereafter, I instructed my counsel to rescind the document. It had become clear to me that that was not the best way forward. That's not how that works. That's not how contracts works. That's not how they work. Really? Nope. My counsel informed me a few minutes later that it had been too late to rescind it. That's what happens. And that Sullivan & Cromwell lawyers were submitting it on my behalf despite my instructions not to. They have a signed contract. Once you sign the thing, they have the thing signed. Like that's what happens. Like you sign something that says, this is my authority. I've transferred it to you willingly, knowingly, voluntarily. And once they have that signed thing, they go and they use the thing. Roughly 6 hours later, more than ample time to change course. Sullivan and Cromwell filed the document with the court against my express wishes and stated orders. You don't have the orders anymore. You're no longer CEO. After that, John Ray filed for Chapter 11 for all entities, including a fully solvent U.S. entity, FTX US, in which they shut down customer access and withdrawals because all of them could be clawed back into bankruptcy. Like that's exactly why all of those transactions were stopped, because they knew the second that the change in CEO occurred that millions of people would be asking for their money out, and they could not allow that to happen, because one of the roles of bankruptcy is to basically claw back assets and make sure that people, in fairness, all people, all creditors, not based on a simple timing judgment, all creditors are able to recover in equal proportion based on their class and rank and creditor status. So yeah, John Ray is famous primarily for his work with the Enron bankruptcy estate. Sullivan and Cromwell recommended John Ray to manage FTX bankruptcy. In the Enron bankruptcy, law firms included Sullivan and Cromwell were paid roughly $700 million. Oh, look at the exclamation points. In fees from funds that would otherwise have gone to creditors. Look at all the exclamation points. $700 million in fees. You mean like when you went out and sought funding for $420 million in investment in a company that wasn't worth that, and you took $300 million of that for your own personal use? So a team of lawyers that restructures a house of cards that receives $700 million in fees for restructuring billions of dollars in assets that was mismanaged. They should get just over, 1.25 times what you got for what? Selling something that didn't exist. So to summarize, to the best of my knowledge, when Enron went through the Chapter 11 process, John Ray and SC were both lawyers and or administrators of the estate, which paid out roughly $700 million in legal fees. Then when FTX crashed, an ex-S&C partner chose S&C to represent FTX. S&C pressured me to file Chapter 11 documents and file the documents despite my instructions not to. Will you guys remember, just for a second here, just for 1 second, this was his anticipated testimony in front of the House Financial Services Committee. In front of the House Financial Services Committee, he was about to go and blame the Chapter 11 bankruptcy for his plight. He was about to go and blame John J. Ray, who's in charge of restructuring this house of cards, for the plight of all customers, completely ignoring everything that had happened prior to that minute. Sir, young man, are you out of your ever mind? Like, just, are you enjoy? Just, this is so fun. So fun. All of it's so fun. John Ray then chose S&C to represent Chapter 11 estate. S&C reneged on an agreement to let me choose the board chair, and then John Ray appointed the board. In an official statement, the Bahamas Attorney General, Ryan Pinder, said, "It is possible that the prospect of multi-million-dollar legal and consultancy fees is driving both the Chapter 11 team's legal strategy and their intemperate statements." Dude, I don't care. I really don't care. Chapter 11 bankruptcies are exceedingly complicated. The expertise that you have to unravel stuff like this, and we'll get to that in a minute, is remarkable. It's remarkable. I've been practicing bankruptcy law for more than 10 years, and I cannot even fathom. You have to have a team of accountants working on this. You have to have a full firm employed to work on every element of these proceedings because of how complicated it is. As of today, I'm still aware of billions of dollars of serious offers for financing, including signed letters of instruction, basically saying, Look, it's verified. Billions of dollars could potentially make customers substantially whole. However, I believe that all of those are conditional on FTX being restarted as an exchange. That ain't gonna happen. Period. No. Respectfully, no. Because here's the funny thing. I don't think this was ever a quote unquote exchange to begin with. This was a game of shadows. You literally displayed promises. That's all you did. You displayed promises. That's all of these forward-facing documents. That's all these forward-facing financial account statements were. They were promises by FTX that this was what the customer had. Every one of those has been demonstrably proven to have been false. So the idea that we're just going to restart this thing that was a house of lies is, I'm sorry, sir, but you are out of your ever mind. However, I admit I'm not optimistic about some parts of this process. I have not myself witnessed any progress by Mr. Ray's team towards raising substantial funds or restarting the exchange. In the few days prior to the Chapter 11 filings, Mr. Miller said, referencing my plans, that a capital raise was a 0% likelihood. In my response to my desire to keep FTX active, Mr. Miller said, there's nothing to save, Sam. There's nothing to save, especially your ass. Like, just, it's not gonna happen. And now we get to the jurisdictional argument, because again, you want to talk about jurisdiction. FTX US, keep on singing your song and dance. There have been a number of misstatements made over the course of the process, which have been inaccurate and substantially misleading. Below is a partial list of the misstatements. These are things that FTX is saying, or Sam Bankman-Fried is saying, were misstatements made by the public, misstatements made by others and third parties in bankruptcy filings, which are pleadings that are being sworn to, one of them being the affidavit by Mr. Ray that was sworn in the bankruptcy case. So yeah, we're dealing with lawyers that are swearing statements in front of a bankruptcy court, a court that is holding them accountable, versus you who are just saying things. 1. Numerous assertions by the Chapter 11 process and team that John Ray is CEO of FTX International. John Ray is not CEO of the primary operating entity or of FTX International. Okay. Numerous assertions by the Chapter 11 process and team that there was unauthorized access to customer funds by the Bahamas. Ooh, this is a fun one. In one Chapter 11 filing, John Ray stated that there was credible evidence that the Bahamian government is responsible for directing unauthorized access to the debtor's system for the purpose of obtaining digital assets of the debtors. That took place after the commencement of these Chapter 11 cases. They have the letter. He attaches the letter to that. Like, he literally attaches the letter. The Bahamas is where FTX International is headquartered. The Securities Commission for the Bahamas is the primary regulator of FTX International. The mind and management of FTX International has been in the Bahamas. You see this? This is a jurisdictional argument. This is kind of cute. This is basically, I went to law school in the first year, and I took civil procedure, and I want to make the arguments for why the Bahamas should be the relevant jurisdiction here. It's where it's headquartered. There's one. It's where it's primarily the regulator. Okay. The mind and management. This is like straight from like Erie Doctrine stuff. It's where the mind of the company exists. Cool. Further, prior to the 11 filings, Securities and Exchange Commission of the Bahamas initiated an administrative process over FTX Digital Markets, the Bahamian entity and operating entity of FTX International, an entity which was thus not included in Chapter 11 filings. That's a jurisdictional argument that's playing out in bankruptcy court, and that argument going to lose. It's going to lose. Mostly because at the end of the day, I'd say it this way, it's a pissing match between the U.S. and the Bahamian government. And based on prior cases, 2 of which out of the Southern District of New York, the Bahamas has a tendency to cooperate with the U.S. government when it comes to securities cases like this. A lot of U.S. investors. So, yeah. Oh, God. I believe that the current Chapter 11 team has significantly overstepped its mandate. Numerous entities were improperly placed in Chapter 11 proceedings by the Chapter 11 team, either because 1, John Ray was not the CEO of the entities. 2, they were not owned by FTX, FTX US, or Alameda Research to begin with. 3, they are subject to other global insolvency processes that preceded and thus supersede the Chapter 11 process. And 4, they were not filed properly. Why are you litigating this in front of the House Financial Services Committee? Why are you trying to make your case in front of them? They were going to grill you today. Why are you selling this? This is not where you go and file your pleadings. This is not testimony in front of the Financial Services Committee. This is you arguing a bankruptcy jurisdiction argument. Why are you doing this here? What is wrong with you? Gee, Rob, a lot. Yes, thank you. Thanks, Rob. Good way to call that out. Yep. So anyways, very fast forward. This is all of his song and dance. He's been doing that the whole time. Let's go ahead and get to where we are today. So where are we today? Sam Bankman-Fried was arrested. That's where we are today. And in being arrested, Sam Bankman-Fried, we have an update on the appearance that he made. Pull up the relevant reports. And what we're going to do is we are going to pull up two separate reports, one of which is this, and it's the Bahamian Press that is share screen, Bahamas tab. As you can see, this report here is from Eyewitness News. This is in the Bahamas. This was released at 3:59 today. Former FTX CEO Sam Bankman-Fried has been arrested. Former FTX CEO Sam Bankman-Fried, SBF, is expected to appear before a magistrate today after police arrested him over the alleged breach of various financial offenses related to the collapse of the crypto exchange. In a statement, Attorney General Ryan Pinder confirmed the arrest followed the receipt of a formal request from the United States that has filed criminal charges against Sam Bankman-Fried and would likely request his extradition. We'll get to that in a second. As a result of the notification received and the material provided therewith, it was deemed appropriate for the Attorney General to seek SBF's arrest and hold him in custody pursuant to our nation's Extradition Act. That's a cooperative agreement with the United States. At such time as a formal request for extradition is made, the Bahamas intends to process it promptly pursuant to Bahamian law and its treaty obligations with the United States. According to police, Bankman-Fried was arrested at his Albany apartment complex shortly after 6 p.m. Multi-million-dollar apartment complex. He was arrested, reference to various financial offenses against the laws of the United States, which are also offenses against the laws of the Commonwealth of Bahamas. Read the police statement. That's the basis for the extradition. It's also one of the bases for the forfeiture action, which has been filed by the United States. So there was a question that was asked on Twitter as to whether he's going to be able to get this house arrest thing and stay in the multi-million-dollar apartment complex. Not if the U.S. gets forfeiture. And based on the fact that these crimes existed and they're crimes that are recognized by the Bahamian authorities as well, that forfeiture action going to work. So just saying, this little statement by the AG or the authority in the Bahamas is suggesting that forfeiture action is going to work. He was taken into custody without incident and will appear in a magistrate court in Nassau, Bahamas, Tuesday, December 13th, 2022. FTX Digital Markets was placed into provisional liquidation by the Supreme Court of the Bahamas on November 10th. The Supreme Court appointed Brian Sims of Lennox Patton, Kevin Cambridge of PwC Bahamas, and Peter Greaves of PwC Hong Kong as the joint provisional liquidators. FTX Trading Limited filed for Chapter 11 bankruptcy in the United States Bankruptcy Court for the District of Delaware back in November 11th. According to the court documents, the cryptocurrency exchange owes creditors $3.1 billion. Say it again, creditors $3.1 billion. That is before proofs of claim have been filed. That is what we know as of today's date, not what it's going to be at the end of the day. The Securities Commission has taken action to freeze the assets of FTX Digital Markets and related parties in the wake of the company's collapse. Responding to Bankman-Fried's arrest, Prime Minister Philip Davis says the Bahamas and the United States have a shared interest in holding accountable all individuals associated with FTX who may have betrayed the public trust and broken the law. Again, cooperation. While the United States is pursuing criminal charges against SBF individually, the Bahamas will continue its own regulatory and criminal investigations into the collapse of FTX. Basically, that's a concession that the U.S. is going to basically be able to prosecute him. This extradition is going to go through based on this statement right here. See, Bahamas has basically said they're going to pursue their regulatory and criminal investigations, but they're essentially admitting that the U.S. is going to pursue criminal charges. Okay, continuing on with the continued cooperation of its law enforcement and regulatory partners in the United States and elsewhere. Let's see if there's an additional update, because I know there is. Because why wouldn't there be? CoinDesk reported this afternoon, 4 hours ago, inside Sam Bankman-Fried's first Bahamas court hearing after his arrest. Nassau, the Bahamas. Former FTX CEO Sam Bankman-Fried told a Bahamas judge on Tuesday that he was not waiving his right to fight extradition to the United States. Jurisdiction. Remember that? So in one of the Twitter spaces, in several Twitter spaces, they were asking him, why is he appearing via Zoom? Why is he appearing via phone? Why is he doing all this? Why isn't he coming back to the U.S. for something that's so important as appearing before the House Financial Services Committee? Someone asked point blank, "Are you worried about being arrested?" No, I don't think so. Looks like he was worried about being arrested. The former titan of industry appeared in Nassau, Bahamas courtroom on Tuesday morning to face an extradition order from the U.S. on federal charges of wire fraud, conspiracy, and other allegations. Bankman-Fried was arrested in Nassau on Monday evening after a magistrate judge signed an emergency warrant for his arrest at the request of prosecutors with the U.S. Attorney's Office in New York. He arrived at the courthouse at approximately 10:30 a.m. wearing a blue suit. Bankman-Fried was not handcuffed, and as he sat alone in the front row of the court, directly facing Magistrate Judge Joanne Ferguson Pratt, who signed the warrant for his arrest on Monday. Before the proceeding could begin, Bankman-Fried's attorney asked the judge for permission to allow his clients to take prescription medication. Bankman-Fried told the judge that the medication was in his possession when he was arrested, but he had not had access to it since Monday, 24 hours. A police officer brought a Ziploc bag of Bankman-Fried's belongings, actually less than 24 hours, in a court which contained his medication. The judge asked if he needed water to take it. Quote, "I don't need water, but I do take my shirt off to take them," Bankman-Fried, who is known to take NSAID passions as an antidepressant, told the court. "Well, you certainly can't take off your shirt in court." That's fair. You general rule, you don't want parties taking their shirts off in court. Doesn't matter who they are, but shirts remain on in court. The judge said before allowing him to leave the courtroom for several minutes to take his medication. Bankman-Fried, who was characteristically jittery before taking his medication, was no longer jittery upon his return. Bankman-Fried's parents, former Stanford law professors who have both taken leave of absence from Stanford. That was my interjection. Joe Bankman and Barbara Fried were seated in the third row behind members of the press. They appeared to oscillate between dejection and defiance, at times holding their heads in their hands and clasping their hands. Bankman-Fried's mother audibly laughed several times when her son was referred to as a, quote, fugitive, and his father occasionally put his fingers in his ears as if to drown out the sound of the proceedings. I don't know why this is added in here, but I will tell you this: if your son is facing extradition, maybe don't laugh at this stuff. That's been part of the problem, is the minimizing and downplaying of every single element of this. Ugh. I will say, I very much appreciate the fact that Bahamas, they decorate their courthouses. This is the courthouse. Look at that lovely pink facade. Wouldn't that just make you feel a little bit better about going into court, bright and sunny? Even though court is not really that kind of place, but yeah. A long shot at bail. Bankman-Fried's Bahamian counsel pushed the judge to consider allowing now disgraced former CEO to post a cash bail. With what cash? After the forfeiture action, by the way, with what cash? That's part of the argument from the United States. No, that's not your cash. That's cash that you derive based on fraud. You don't get to use that to post bail. You don't get to use customer money that you defrauded to post your bail. Arguing that his client was not a flight risk. This lawyer, by the way, is Mark Cohen. The lawyer told the court that Bankman-Fried was a permanent resident of the Bahamas for, quote, many years. Bankman-Fried is reported to have lived in Albany since 2021 and owns real property here, real estate. Prosecutors pushed back, arguing the extradition treaty with the United States required the defendant to be held in custody. Custody, my lady, custody, the prosecutor told Judge Ferguson Pratt, which has one meaning, whether it's Webster's dictionary or Oxford or otherwise. Custody is inconsistent with the act of bail. I like the directness of that prosecutor. Well done. The judge told the courtroom that she had been wrestling with whether or not to grant him bail since signing the warrant for his arrest. This is the judge. On a good day, I don't drink, ask anybody, she said. But yesterday, I was sure going to drink. Dude, only a judge in the Bahamas is saying that. Wow. That's a judge. On a good day, I don't drink. Ask anybody, she said. But yesterday, I was sure going to drink. Okay. Go judge. Bankman-Fried's lawyers argued that he has had opportunities to run up to the moment the FTX issues became public and did not take them. He thought he was safe in Bahamas. His lawyer added that the flight risk can be mitigated by electronic monitoring systems and a large cash bail. The judge seemed unconvinced and told the attorneys that she had several cases in which defendants forfeited cash bail and went on the lam. Also, good for the reporter for saying that one. The went on the lam. Don't see that enough these days. The Creole expression is, I'm going to butcher that one. Allez, Judge Ferguson Pratt said. They never came back. Bankman-Fried's lawyers have requested bail, according to Reuters, to basically alleviate any concerns. He was not granted bail. The bail request was denied. That was the result of that outcome. That was reported about an hour and a half ago. So, yeah, no. So let's do this. We're going to go through the charging document, and then we will do a little recap, and then we'll get into some of the CFTC and the SEC complaints. So let's pull up the charging document. Share the screen. We share the screen. We do the indictment. Count one. So in the United States District Court for the Southern District of New York, this is the sealed indictment that was filed yesterday that was unsealed this morning. United States of America versus Samuel Bankman-Fried, a.k.a. SBF. Even the federal charging document calls him SBF. Like really? I mean, Emily said this earlier, but EDB. Like, are we just going to, is this just now we're going to talk about like, that's it? Acronyms? That's all we're known? All right, I'll be RDM. It doesn't matter. Count one, conspiracy to commit wire fraud on customers. The grand jury charges. So this was brought before a grand jury. Several people have made comment. I have in the past. It's well known that you could convince a grand jury to charge a ham sandwich. You can. However, in this case, I don't think they needed very much, especially when we get to the CFTC complaint. That's going to be really interesting. From at least in or about 2019, again, vague. So up to and including in or about November 2022 in the Southern District of New York and elsewhere, Samuel Bankman-Fried, SBF, the defendant, and others known and unknown. By the way, this little tidbit here, and others known and unknown, willingly and knowingly did combine, conspire, blah, blah, blah. The others known and unknown means that there are more charges coming. That was actually stated by the U.S. attorney handling this case. There are more charges coming in this case, and it's just a matter of who they lump into it. Willfully and knowingly did combine, conspire, confederate, and agree together with each other to commit wire fraud in violation of Title 18 of the United States Code. It was a part and object of the conspiracy that Samuel Bankman-Fried, SBF, and others known and unknown, all those things, having devised and intended to devise a scheme and artifice to defraud and for obtaining money and property by means of false and fraudulent pretenses, representations, and promises, would and did transmit and cause to be transmitted. This is the wire fraud. So let's just read through the charges in general. They're pretty straightforward. You have wire fraud, which is, I mean, the government can charge just about anything as wire fraud. It's pretty big. You send money, fraud, over wire, which is essentially anything, mail, phone, text, email, doesn't matter, anything. And the government charges you for wire fraud. Wire fraud on customers, simple enough. Wire fraud, defrauding customers. Okay. Count three, conspiracy to commit wire fraud on lenders. Basically, they were trying to borrow money based on the wire fraud. Count four, wire fraud on lenders. They committed wire fraud on lenders. I mean, this is really not complicated. Like, the charging instrument here really isn't that hard. Count five, conspiracy to commit commodities fraud. We'll get to that with the Commodities Futures Trading Commission in just a second. Count six, conspiracy to commit securities fraud. We get to that one with the SEC. Count seven, conspiracy to commit money laundering. That's a fun one. CFTC lays that one out pretty good too. Basically, yeah, we'll get to that. This is a very broad allegation that just lays out a bullet point allegation. It asserts the basis, statutory bullet points of what you have to prove without any specific detail. But the CFTC complaint that we're going to review in just a second, that lays it out pretty well. Conspiracy to defraud the United States and violate campaign finance laws. That one's a little bit funny too. So we're going to have to see what that one basically gave money to third party under false pretense / some third party conduit to fund campaigns in avoiding finance limitations. Forfeiture allegations. We take your shit. All right. So before we proceed, let's go ahead and do this. I want to bring up these. So we're going to listen to Mr. Ray testify before Congress. So tell me if you can hear this. You guys hear? Waiting for the delay. Can you hear the audio? Please let me know. Dang it. Let's see if we can do it this way. All right, how about now?
Kate, how much time you have left? I would ask you to be mindful of the timer so that we can be respectful of everyone's time. Mr. Ray, you are now recognized for 5 minutes to present your oral testimony.
Chairwoman Waters, Ranking Member McHenry, distinguished members of the committee, thank you for your invitation to appear today. I truly appreciate your interest in this matter, and I hope my testimony can be helpful to you as the committee continues its inquiry into the collapse of FTX and the efforts that are underway to help those who have been harmed. I accepted the position of Chief Executive Officer of FTX in the early morning hours of November 11. Immediately it became clear to me that Chapter 11 was the best course available to preserve any remaining value of FTX. Therefore, my first act as CEO was to authorize the Chapter 11 filings. I've implemented a 5-part bankruptcy plan, which is detailed in my written statement. Our overarching objective is to maximize value for FTX customers and creditors so that we can mitigate to the greatest extent possible the harm suffered by so many. The FTX Group's collapse appears to stem from absolute concentration of control in the hands of a small group of grossly inexperienced and unsophisticated individuals who failed to implement virtually any of the systems or controls that are necessary for a company entrusted with other people's money or assets. Some of the unacceptable management practices identified so far include the use of computer infrastructure that gave individuals in senior management access to systems that stored customer assets without security controls to prevent them from redirecting those assets. The storing of certain private keys to access hundreds of millions of dollars in crypto assets without effective security controls or encryption. The ability of Alameda to
BT-Dub, what he just testifies to right there is what is being suggested as the possibility as to why several $1 million was taken out of FTX after the bankruptcy filing was the absence of really true encryption methods that were, well, they had little keys that were hidden back doors. So, yeah.
to borrow funds held at FTX.com to be utilized for its own trading or investments without any effective limits whatsoever. The commingling of assets, the lack of complete documentation for transactions involving nearly 500 separate investments made with FTX Group funds and assets, and the absence of audited or reliable financial statements, the lack of personnel in financial and risk management functions, and the absence of independent governance throughout the FTX Group. The fundamental challenge we face is that we're in many respects starting from near zero in terms of the corporate infrastructure and record keeping that one would expect in a multi-billion-dollar corporation. Still, in just over 4 weeks, we've instituted meaningful steps to gain command and control, and every week we gain a better understanding of what occurred and the path forward, all of which will be shared with interested parties and affected parties throughout the Chapter 11 processes. The scope of our investigation is truly enormous. It involves detailed tracing of money flows and asset transfers from the time of FTX's founding and complex technological efforts to identify and trace crypto assets. We're in the process.
Guys, I see in the chat trying to read his body language. I can tell you, based on having observed several people testify in front of Congress, this is not abnormal. You have to hunch down to reach that microphone. Any attorney who's ever had to talk into a microphone knows this struggle. You are often hunched. There's really nothing about his body language that gave any indication that he was doing anything bad here. He's answering questions. He did very good. He was very straightforward.
Process of collecting and reviewing dozens of terabytes of documents and data, including billions of individual transactions. We're leveraging sophisticated technology and expertise to identify and trace additional transactions and assets. While many things are unknown at this stage, we're at a very preliminary stage, many questions remain. We know the following. First, customer assets at FTX.com were commingled with assets from the Alameda trading platform. That much is clear. Second, Alameda used client funds to engage in margin trading, which exposed customer funds to massive losses. Third, the FTX group went on a spending binge in 2021 and 2022, during which $5 billion was spent on a myriad of businesses and investments, many of which may only be worth a fraction of what was paid for them.
Mm-hmm.
Fourth, loans and other payments were made to insiders in excess of $1.5 billion. Fifth, Alameda's business model as a market maker required funds to be deployed to various third-party exchanges, which were inherently unsafe and further exacerbated by the limited protections offered in certain of those foreign jurisdictions. I know that resolution of the Chapter 11 process, as well as the investigation into the cause of the FTX Group's collapse, are of keen interest to this committee and to your constituents. Although, there are many who need and deserve answers. There's customers, there's creditors, there's investors, counterparties, employees, and regulators. We're positioning ourselves to provide each of these constituents with answers that they deserve. Although a bankruptcy proceeding of this unprecedented nature will take some time to run its course, I'm committed to working as quickly as possible to investigate what happened, formulate conclusions, and hopefully inform the committee's work here. I should note that my ability to comment on certain of the matters today will be inherently limited by the state of FTX's records, ongoing bankruptcy proceedings, and of course, the numerous ongoing investigations by the U.S. law enforcement regulators. I look forward to answering your questions to the best of my ability. Thank you again for allowing me to present in front of this committee. Thank you.
All right, so what do we learn from the testimony that happened today? Well, apart from the fact that Congress has no idea what crypto is or how to regulate it or anything that takes place, we learned that essentially Mr. Ray has a massive and monumental task in front of him as far as managing this is concerned. It's ain't gonna be easy. We also learned that FTX is their accounting software for, again, a multi-billion-dollar exchange was QuickBooks. QuickBooks. Now, I'm not faulting people that use QuickBooks for their companies, but tell me that QuickBooks is the appropriate software for something like this. We also learned that they would verify trades via instant messenger. Just all the bad things, and that there would be no record of those verified trades. So, surprise, freaking prize. While I was watching that, I was just pulling up the bankruptcy docket to see if there's been any updates on the bankruptcy case. We've got some matters scheduled for hearing. These are just extending time to file lists of creditors and secured interest holders, a bunch of pro hoc vice attorneys seeking admission on behalf of various creditors and parties. Then we've got essentially liquidation updates from companies that are providing certifications and statements as to where they're finding, and that we've got employment applications for liquidators, basically standard stuff into Chapter 13, or sorry, Chapter 11. Chapter 13 is a baby 11, personal 11. Scrolling the bankruptcy updates. Nothing. Notice of appearance, request for service, notice. Basically, anyone and everybody is now showing up to the bankruptcy case. That's what we've got. So right now, everything's proceeding in Delaware. Bankruptcy case is moving forward. People are filing claims. That's where we are. Oh, poll. End poll. Oh, surprise, surprise. 92% of you said that he would use it for his own purposes, the money, the $8 billion, and then 8% of you, which 8%, said spend on self. So 933 votes. Pretty good numbers. All right, let's do this. I want to pull up the CFTC and the CFTC charges or the CFTC complaint because that has the most detail, and that's probably going to be our most interesting discussion. But before that, I want to do something that I always forget to do. YouTube. There are 1,600 of you guys watching right now. If you don't mind, I know that I always fail to do this at the right time. If you wouldn't mind liking the video, it does really do a lot to push the video to people who are looking at it. We are reviewing legal pleadings. I think it's pretty kind of pressing given today's developments. So if you wouldn't mind, just hit that like button. And if you do like the content, I don't always do the regular weekly streams like this, but weekends and Friday nights and Wednesday night Trials of the Century, please go ahead and subscribe. So let's hit a few super chats before we get on to everything else. Courtney S., thank you. Oh my God, Rob, you're life size on my TV screen in the living room. That's creepy, but awesome. Travel Hound, thank you. The collective support of the LawTube community to pitch in for Captain Corey was insane. You guys rock. That is a general reminder to go check out Cracking the Box. Captain Corey, let's get him 200,000 subscribers if we can. Young man is basically in end-of-life care after having 2 heart transplants and wanted to always be a YouTuber and wanted his channel to get to 100,000. We achieved that goal very quickly, and now we've set a new goal of 200,000, and we have play buttons heading his way. Heather, thank you very much. You would have been fine to leave it till Friday, but then Sam Bankman-Fried got arrested. True. Linda DB, thank you very much for the chat. Thank you for your kindness, Rob. Thank you very much for that. I'm happy to share where I can. Sky's Neighborhood, have you heard of Corey's intro song? It's fabulous. It is pretty cool. Check out the channel if you haven't done yet. Thank you. Travel Hound, I have a working theory. Carolina is dumping SBF in it. She's working with Southern District of New York and cutting a deal. There are a lot of speculations. I don't know that that one is really off base. We'll see what happens. There are more charges to come. We know that from the prosecutor in the case. Jan E. Wallace, thank you very much. It's a great thing you're doing for Corey, Rob, just to make people aware that things may take longer to get to Corey due to Royal Mail strikes. Be patient with it. Nice to make a live. I'm glad you're here, Jan. Thank you very much for that. I am putting together a care package of my own. So thank you for that advice. I will let you guys know, and I'll keep you updated via Twitter. Nicholas, thank you very much for that, my friend. After the news of SBF's arrest, I was expecting you to wear a party hat and blowing a kazoo as intro. No, but we have this. So just, that's what we have. Thank you. VV Poo, thank you very much for the super chat. What happened to SBF's partner, Gary Wang? Did he get smart and dip out early? He's being sued left, right, and center as well. We've got various updates on that. Chrissy Lee, thank you very much. I took the advice. Thanks for the distraction. Thank you, Chrissy. Wonderful advice. Thank you for supporting the channel. Always love having you here. Thank you very much. Sarah Lee, maybe he pledged it. Fair assessment. Truffle Hound, hubris. Sam's hubris is his Achilles heel. You guys, we read their testimony. That was something else. Uncivil Law, Rob Coin is going to the moon. This is a great reminder from Uncivil Law that I get the opportunity. There has been, and there have been, every single case I've covered, all of the FTX stuff, every time I want to talk about this, there are people that show up in my comment section who are not me, but they have a picture of me. And they purport to be me, and they try to sell you stuff, and they say, contact me on WhatsApp. I don't contact anybody on WhatsApp. I don't contact any of you guys and ask you for information. And I certainly don't do it in the comment section of my own videos. It is not me. I am not selling anything, and I am not trying to give you investment advice. Talk to your investment advisors. Talk to them specifically. It ain't me on YouTube. I'm not asking you. If you do see those, report them, flag them, do whatever you have to do. Just make them go away from my channel. Yes, just no, it's not me. I'm not selling anything. Moffat on money. Thank you very much. Thanks for the mention, Rob. That was exceedingly kind. Much appreciated. Thank you. Moffat, thank you for making that content. That was a very well done video. It was a very good way of explaining how the crypto industry works, how these market exchanges work, and really how this entire thing should be looking at. While I can talk about the legal stuff very well, sometimes I can't talk about both on the same live stream because honestly, we would be streaming for about 5-6 hours. I don't have that time. Also, it's kind of an intersection of the area where I am familiar with it, but nowhere near someone who practices in it every single day. So I'm happy to defer to experts who do know how to talk about it. So thank you. Nurse Jojo, your explanation of this whole fiasco helps me understand it, but also crypto in general. I was also skeptical. Glad for that. It is, speak to your financial advisor. Let them know what is going on. They will advise you and coach you appropriately. Just make sure that's not Sam Bankman-Fried. Truffle Hound, John J. Ray is a boss. I'm a big fan, big time fan. He has been an interesting person to watch. He did the Enron liquidation. That took time. This is going to take a lot of time. It's going to be years before any distributions get made. They are going to partition off enterprises or entities within the umbrella that are profitable and seek to sell those to reputable reputable stakeholders / marshals of the enterprise. So those are going to be sold off. The other one's going to be liquidated, and they're going to try to get some money back to distribute to creditors. 9-Inch Nails Gal, thank you for having a deep enough voice that you don't sound like a chipmunk when I need 2x to catch up because I'm late. I'm sorry. I was talking really fast today too. So Truffle Hound, thank you very much. Sam, honey, we don't need your help. You've done enough. We're good. We have John Ray. Sincerely, everyone. Yeah. Good and accurate assessment there. Vez from Quebec. Murder in, murder out. Keep breathing, Rob. I have been. It's been interesting. KWNY upstate. He will have liquidity problems after having to digest prison food. I made a little comment. May the extradition be swift. May the plane flight back up north be bumpy, and may he be served nothing but stale and extra salty peanuts. Truffle Hound, thank you very much, my friend. Dubai, cool. If he feels like he's being unfairly treated now, let's extradite him and see how he feels in a Sharia court. Oof. Emiratis don't like being cheated, and their judicial system is, quote, efficient. I think they mean something different by efficient, but your point is noted. Rob, you beautiful soul, I'm joining replay crew. Good night. By the way, it is Milena. Thank you, Milena, very much. P.S. Curtis is sweet, sweet teddy bear. Yep, I saw last Friday Night Frenzy. Thank you very much, Milena. And now I know that that's Milena, so thank you. Against the Tide, deep breaths, breathe in, breathe out. Thank you very much. Against the Tide. 9-Inch Nails Gal. Unicorn stress ball squeeze time, Rob. That's fun. Now I see why Mike likes it. It's kind of fun. Tiffany Bernier. Anyone have Rob's email I can't find? It is lawandlumber@gmail.com. It is lawandlumber@gmail.com. 9-Inch Nails Gal, 1994. SBF is a toddler and his lawyer is the mom trying to keep him alive. I think at this point, the lawyer is in a corner crying and banging their head. That lawyer is no longer in the corner anywhere. He's probably sitting there going, told you, tried to tell you, and now it's Mark Cohen's problem. Just because he says that, like, you can drunk text bankruptcy. Yeah. That was a full, like, he's like, I docu-signed something. No, the thing you docu-signed is called a contract, and you read it, and you had the opportunity to read it, and you had counsel that was walking you through it. So no, you don't get to just say, didn't mean it. Victor Man 7777. Lawyers obviously got that for doing nothing, according to SBF. Seriously. That Sarah, not the Sarah or the Sarah, but that Sarah. The night hours before SBF filed bankruptcy, he was calling C-suite at Coinbase and others begging again for a bailout, and he got shut down hard again. Yeah, he was doing that all week long while he was saying, there's no problems, there's no problems. Nick Loss, thank you very much for the generous super chat. I've met people like SBF in negotiation through years. The personality is the same at billionaires and millionaires. I sit there, nod, and smile sympathetically, and then I stop nodding and smiling. The deflation. This is, I don't know what he was intending to prove today by testifying, but I can tell you that testimony wasn't going to do it. Viking Wolf by Blood, thank you very much. What SBF and AH in a room together with their wordful words. I want to see who wins. I don't. Oh, I don't. Oh, the frustration of you thinking about that. Truffle Hound, thank you very much. SBF uses separate and commingle synonymously. That was good. SBF uses separate and commingle synonymously. Just about. M169, thank you for the generous super chat. Off topic, I will just have to listen on Friday as I'll be at work. Counting every pill, syringe, and test strip in our pharmacy. Whatever y'all are drinking, have one for me. I know you'll have me laughing for sure. Cheers, M169. Glad you're here. Best of luck at work, and we'll catch up with you on Friday. Travel Hound, thank you again. SBF's written testimony. Written quote, testimony is enough to drive me to drink red wine and Coca-Cola. Still not there yet. Goodbye, sweet friends. Much love. Thank you for tuning in. Tianina, regulators mount up. Tianina, this is going to be, I mean, they had no idea what they're doing. They really didn't. Bridget Lazarco as the CPA, QuickBooks as the software, facepalm. When that got revealed in court or in the hearing today, oh my gosh. I think Twitter kind of exploded on that one. Heather, Moffat on Money is now at 249 subscribers. Was it 35 when the stream started? You guys, Moffat on Money. I liked that video. It was good content. I have no problem promoting that. It was great educational content. You guys want to learn something? That was good content. To whomever suggested that to me on Twitter, I apologize for not getting it right now, but I will say thank you. I think I already said thank you, but yes. Marnie Knight, thank you for the stream. You're amazing. Thank you very much, Marnie Knight. Very much appreciated. Sarah Lee, how can one tell if their financial advisor is an SBF? Hashtag asking for a friend. If they are saying that there is all upside and no downside, they are an SBF because he was actually saying that. If they are saying that they are FDIC insured and they are not, he is an SBF because he was actually saying that. So we'll get to that in a second. Suso, please explain why Congress can't force SPF to testify. That testimony would destroy some high up people, in my opinion. This is something a lot of people were asking about. Congressional testimony is not what people think it is. Congressional testimony doesn't actually hold people to the fire. Congressional testimony is an opportunity for politicians to grandstand, say 5 million different things, and then say, is that true or not true? And then regardless of what the person says or the witness says, they then just go on making accusations. That's what congressional hearings do. The idea that they ever discover anything that you could not discover in a court of law, or for example, a prosecution, or for example, a civil suit, of which there are many, is ridiculous. Congressional hearings are theater. That's what it is. As just a pragmatic person coming and saying it for what it is theater. I don't care what side of the aisle you're on. I don't care who's in charge. It is political theater. They care about nothing except their own political self-interests. And anytime they say the American people deserve, that is quite literally for a talking point they want to make on the campaign trail. So the idea that he would have shown up to Congress and we would have learned anything that we didn't already learn in his written testimony, which he was stupid enough to provide, is ridiculous. Because tell me also any one of the congressmen or women who are sitting there asking questions who would have been able to dissect any of that. I was out on Twitter earlier this week basically saying, hey, staffers, if you have not talked to the people in the Twitter spaces who have hosted these or who have asked questions during these, you need to get on the phone and call them because they're the ones that actually know what's going on. So, yeah, that didn't happen. Turns out it didn't really need to happen because there was an arrest. Damn, that's sad and true about Congress. It is. It really is. It's frustrating. It really is frustrating when you are sitting here and you trust Congress to basically do something, and all they do is seem keen on making talking points. They were pointing fingers at the SEC. They point fingers at everybody except themselves, or they point fingers at the other party. Syracuse Brad, how dare you accuse Congress members of self-interest? J'accuse. I think I pronounced that right. If I did, let me know. If I didn't, correct me. J'accuse. I think that means what say you? Something to that effect. Don't know. But yeah, okay, let's go to the CFTC complaint because this one has the deets. Share the screen, share the tab, and then CFTC complaint. Okay, Trisha Lynn has corrected me. No A. J'accuse. J'accuse? I accuse you. I accuse you. Thank you for the correction. French is not my language. All right, in the United States District Court for the Southern District of New York, same court, different case. Commodities Futures Trading Commission, the plaintiff, versus Samuel Bankman-Fried, FTX Trading, Limited, doing business as FTX.com, and Alameda Research LLC. Complaint for injunctive and other equitable relief and for civil monetary penalties under the Commodity Exchange Act and Commission regulations. Jury trial demanded. Now, an interesting thing here. I don't believe, so FTX trading is in active bankruptcy. That's kind of funny. This is regulatory action. I wonder if they actually are exempted from the automatic stay. Generally speaking, you have to seek permission from the bankruptcy court to file any action that's adverse to the entity. I'll have to look at that. I wonder if they sought prior authorization, or if they're seeking, or if they're going to file this and then go back to the bankruptcy court and say, hey, justify or say that we're exempt from the automatic stay so we can prosecute this. So the plaintiff, Commodity Futures Trading Commission, CFTC, or the commission, by and through undersigned attorneys, hereby allege as follows. CFTC, this is a civil complaint. This is seeking monetary penalty. That's what it does. Samuel Bankman-Fried. Oh, they didn't use SBF. This one uses Bankman-Fried. We're going to use SBF. Co-founded Alameda Research, a digital asset trading and investment firm in Berkeley, California in 2017. In May of 2019, he and others launched FTX Trading Out Limited. That's supposed to say doing business as FTX.com and various subsidiaries, affiliates, and related entities. Collectively, FTX.com, or simply FTX, a centralized digital asset exchange. These parties are collectively referred to as defendants. Alameda and FTX were large and well-known players in the digital asset industry, and Bankman-Fried was their young, high-profile leader. At its peak, the daily trading volume of FTX.com was over $20 billion in daily trading. So back to that QuickBooks comment, $20 billion in daily trading. And it had garnered a $32 billion valuation. I don't know if that's really the case, but sure. FTX had prominent paid partnerships, including the naming of rights to professional sports arena in Miami, since been sought to be revoked, celebrity endorsements, and a 2022 Super Bowl commercial that touted FTX as the, quote, safest way to buy and sell crypto. That aged well. On November 11, 2022, Bankman-Fried's empire abruptly collapsed. FTX customers in the world at large discovered that FTX, through its sister company Alameda, had been surreptitiously siphoning off customer funds for its own use, and over $8 billion in customer deposits were now missing. Beginning no later than May of 2019 and continuing through at least November 11th, the relevant period, SBF owned, operated, and or controlled FTX, along with its numerous subsidiaries and related entities around the world. He also owned, operated, and controlled Alameda. Same thing, all its subsidiaries. Throughout the relevant period, Alameda operated as a primary market maker on FTX.com, providing liquidity in its various digital asset markets, and also performed a number of other key functions for the exchange. SBF operated defendant entities as a common enterprise. No barrier between the two. Throughout the relevant period, and unbeknownst to all but a small circle of insiders, FTX customer deposits, including fiat currency and digital assets such as Bitcoin and Ether, were intended to be used for trading, and custodies on FTX were regularly accepted, held by, and or appropriated by Alameda for its own use. They were supposed to be on FTX. Alameda used them instead. At SBF's direction, FTX executives created features and underlying code for FTX that allowed Alameda to maintain essentially unlimited line of credit on FTX. Essentially, FTX lent money to Alameda. Alameda never had to pay that back, ever. All of the money in FTX was used for Alameda's purposes, and Alameda never had to pay it back. Unlimited loan. Cool, right? FTX trading executives also created other exceptions to FTX's standard processes that allowed Alameda to have an unfair advantage when transacting on the platform, including quicker execution times and an exemption from the platform's distinctive auto liquidation risk management process. Basically, when shit went sideways, the company could call all margins. This was exempt from that. Shit goes sideways, Alameda is protected. Throughout the relevant period, at the direction of SBF and at least one Alameda executive, that might be Allison, by the way, Alameda used FTX funds, including customer funds, to trade on other digital asset exchanges and to fund a variety of high-risk digital asset industry investments. SBF and other FTX executives also took hundreds of millions of dollars in poorly documented loans. By the way, CFTC, good for you for throwing that in quotes. Nice shade. Quote unquote loans from Alameda that they used to purchase luxury real estate and property, making political donations and for other unauthorized uses. They appropriated your shit. They appropriated your shit. That's what that is. Throughout the relevant period, defendants, through a web of subsidiaries, that web of lies, and other related entities, collectively, the FTX enterprise misappropriated customer funds for their own use and benefit. Despite this, FTX Trading represented in its terms of service, which is a promise to consumers, and elsewhere, the customers were the quote owner of all assets in their accounts. You see how they put the owner in quotes. That's suggesting bad things happen. And had control, also in quotes, of the other assets at all times, and that those assets were appropriately safeguarded and segregated from FTX's own funds. False. Through this conduct and the conduct further described herein, defendants violated Section 6C1 of the Commodity Exchange Act, or the Act, 7 U.S. Code Section 9.1 and Commission Regulation, the Regulation, 180.1a. 17 Code of Federal Regulations, Section 180.1a, lots of numbers. Unless restrained and enjoined by this court, defendants are likely to continue to engage in the acts and practices alleged in this complaint and similar acts and practices as more fully described below. If we don't stop them, they will continue doing this crap. Accordingly, the CFTC brings this action pursuant to Section 6C of the Act to enjoin defendants on lawful practices and to compel their compliance with the Act. Stop doing your shit. In addition, the CFTC seeks monetary penalties and remedial ancillary relief, including but not limited to trading and registration bans, get off my platform, disgorgement, give me back my shit, restitution, give them back their shit, pre and post judgment interest, pay interest on the shit you took, and other relief as the court may deem necessary and appropriate. Jurisdiction. I don't want to go through. We're not doing jurisdiction. Parties. CFTC. What is the Commodities Futures Traders Commission? It is an independent federal regulatory agency charged by Congress with the administration and enforcement of the Commodity Exchange Act. Okay. Samuel Bankman-Fried is a U.S. citizen who has resided in various locations during the relevant period, most recently in the Bahamas. Harken back to the testimony. I'm a Bahamian resident. Bankman-Fried is the founder of a majority owner of FTX Trading, Alameda, and FTX US. Not really anymore, but sure. Bankman-Fried resided in and performed work for FTX Trading and Alameda in various locations during the relevant period. That's true. And he has never been registered with the commission in any capacity. Also true. FTX Trading. FTX Trading Limited is a corporation registered in Antigua and Barbuda. FTX Trading, along with its subsidiaries and affiliate entities, including without limitation FTX Digital Markets, located in the Bahamas, collectively did business as FTX.com, this is the exchange, or FTX, and operated a digital asset trading exchange during the relevant period. FTX Trading had numerous employees, including key personnel that were based in and performed work from the United States, including in this district. FTX Trading had regularly engaged in advertising and promotional activities in the United States. See Tom Brady, Kevin O'Leary, Miami Heat, Super Bowl. None of the FTX Trading entities has ever been registered in the commission in any capacity. FTX Trading is currently in Chapter 11 bankruptcy proceedings in the U.S. Bankruptcy Court for the District of Delaware. That's what I said there. Alameda Research is a Delaware limited liability company. Alameda, along with its parent, subsidiary, and affiliate entities, collectively operated and did business as the digital asset trading and investment firm Alameda. It was founded in, maintained offices in, and had numerous employees, including key personnel that were based in and performed duties in the United States during the relevant period. This is the U.S. clapback on jurisdiction. None of the Alameda entities have been registered with the commission in any capacity. Alameda, same Chapter 11. During the relevant period, FTX Trading, Alameda Research, together with other entities under the majority ownership and control of Bankman-Fried, operated as a single, integrated common enterprise under the sole ultimate authority of Bankman-Fried as their mutual owner. They are referred to as the FTX enterprise. Doesn't that sound ominous? Bankman-Fried regularly exercised control over each of the component entities of the enterprise throughout the relevant period, including regularly serving as signatory on core corporate agreements, as well as corporate bank accounts and trading accounts, many of which were held in the U.S. The FTX enterprise failed to observe corporate formalities, including failure to segregate funds, operations, resources, and personnel, or to properly document intercompany transfers or funds and other resources. They did not do the shit they were supposed to do. The entities regularly shared office space and bedrooms. Systems, accounts, and communications channels on information belief assets flowed freely between FTX enterprise entities, often without documentation or effective tracking. The purpose of the Act, Commodities Exchange Act, is to serve the public interest, blah, 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 regulation. We want to deter and we want to prevent price manipulation. We want to do the things to create market integrity. That's what the Act is for. And to prevent fraud and the abuse of practices for sales and misuse of assets, basically to prevent everything the FTX did. A digital asset is anything that can be stored or transmitted electronically and has associated ownership or use rights. Digital assets include virtual currencies such as Bitcoin, Ether, ETH, or Tether, USDT. Ether and Tether are stablecoins, but continuing on, which are digital representation of value that function as mediums of exchange. Think back to the dollar. Units of account and or stores of value. Certain digital assets are commodities, including Bitcoin, Ether, or Tether. Those are the more stable coins, and others as defined under Section 1A(a)(9) of the Act. In recent years, as digital asset markets have evolved, the CFTC has approved the offer of futures contracts on digital assets, including Bitcoin and other Ether futures and options, by boards of trade registered with the Commission. Basically, these assets were significant enough and enough that they fell under the purview and were thereby regulable under the Act. The code section makes it unlawful for people to directly or indirectly use or employ or attempt to use or employ in connection with any swap or exchange of sale or of any commodity in exchange, or for future delivery or subject to rules of any registered entity in exchange, any manipulative or deceptive device or contrivance in contravention of such rules and regulations that the Commission shall promulgate. Oh, come on. We're not going to do all this. User employee, blah, blah, blah. I can't use manipulative device, scheme, or artifice. You cannot make untrue or misleading statements of a material fact to state a material fact necessary in order to make statements made not untrue or misleading. You cannot deceive people to buy your shit. Engage or attempt to engage in any practice or course of business which operates or would operate as a fraud or deceit upon any person. You can't defraud people with the exchange. Sorry, just kind of cutting through. Section 13 provides that any person who directly or indirectly controls or has violated any provision of this chapter or any of the rules, regulations, or orders issued pursuant to this act may be held liable for such violation in any action brought by the Commissioner to the same extent as such controlled person. Anyone does it on your behalf, they're responsible too. You're responsible, they're responsible. In such action, the Commission has the burden of proving that the controlled person did not act in good faith or knowingly induced, directly or indirectly, the acts constituting a violation. They knew what they were doing was wrong. They prove it, you're in trouble. The founding, this is all kind of basically, this stuff is kind of boring. Let's get to the meat of the allegations. Here we go. So by late 2018, Bankman-Fried and others employed at Alameda's offices in Berkeley, California, had begun building the centralized digital asset derivatives exchange, which would ultimately become FTX. A fraud is beginning. The platform development was funded in part by another digital asset exchange, Binance, which, upon information belief, had acquired approximately 20% stake of FTX in or before November of 2019. I believe they gave FTX a $500 million valuation with that because I think it was a $100 million buy-in. In early 2019, SBF and others moved to Hong Kong to finalize the launch of FTX trading platform to the public. The FTX.com website was launched and made available to the public by no later than May of 2019. SBF was at all times during the relevant period the majority shareholder of FTX trading and related entities. I think 90% was the ownership. Oh. Okay. FTX offered trading in a large variety of digital assets, including digital commodities such as Bitcoin, Ether, Tether, and others. FTX operated primarily as a derivatives exchange and offered trading in various types of options, futures, swaps, perpetual swaps, and other digital commodity derivative products. Basically, not the shit, but betting on the shit. FTX allowed customers to place buy long, sell short order. So long and short. They allowed them to long or short the other assets and match customer orders via its trading engine or matching engine. FTX also offered a number of additional services related to trading of digital asset products. For example, FTX operated a peer-to-peer margin lending program where customers could offer margined or leveraged offerings to one another. Oh, God. Customers could access the FTX platform through the FTX website, application program, the API. It also offered over-the-counter portal that allowed people to access and request quotes for spot digital assets and trade directly, so you could go onto their app. Marketing materials and in communication with federal regulators and others, FTX touted its auto liquidation and risk management engine. Basically, if shit starts going sideways, they can stop it. Cross-margin functionality and backstop liquidity provider, BLP programs, as unique features that limited risk. There was no risk limitation whatsoever. Alameda was a leading participant in the BLP program, backstop liquidity provider, basically. FTX relied on Alameda resources, money that was provided by you, funds and personnel to carry out a number of core functions of the FTX.com platform. This plays to the intertwining of the two entities, including created liquid submarkets for all of the products offered on FTX trading, maintaining an appropriate balance of various digital assets on the exchange and supporting peer-to-peer margin lending program. You could make trades based on loans. So essentially, you would have to put up a certain percentage. You would borrow this other percentage when you made that trade. To the extent that trade went south, they would come back to you and you would have to pay money back. FTX grew quickly. By June 2019, for example, just a month after its launch, according to FTX, the daily volume of futures trading on FTX often exceeded 100 million. Beginning no later than 2020, FTX trading was consistently ranked as one of the largest digital asset exchanges in the world by trading volume. In 2021, according to FTX entities held approximately 15 billion in assets on other platforms. FTX entities accounted for approximately 10% of the global digital asset volumes, and they transacted 16 billion of volume per day. I want you to think about this as far as currencies are concerned. Imagine the global enterprise of all different currencies when we're trying to talk about how big of an enterprise FTX was. So all currencies in the entire world, right? So you have to figure that the US is a certain percentage of all of those currencies as far as value is concerned globally. Imagine 10% of the currencies, 10% of all world currencies being FTX. And now imagine this liquidation, the bankruptcy, and 10% of the world currencies go gone. Which is why you're seeing ripple effects just go everywhere throughout all of crypto. Because of the perception of potential conflicts of interest between FTX and Alameda, defendants and their employees understood that it was improper to present a public perception that there was it was important to present a public perception that there was strong separation between Alameda and FTX. Basically, because there were conflicts of interest, FTX being exchange, Alameda being money and investment. So exchange is your shit, investment is their shit. They had to present big wall between these two. On information belief, this was one key motivation for Bankman-Fried's resignation as CEO of Alameda. He was CEO of both, by the way, for a while. Yeah, that's a problem by itself. SBF and others reinforced a separate spheres narrative in their public statements. Nobody look, we're completely separate. We totally have a firewall between us. We're totally different enterprises. For example, in August 2022, during a media appearance, Alameda's CEO said the following with respect to the nature of the relationship between FTX and Alameda. They're both owned by SBF. Red flag. Obviously. So ultimately, sort of aligned incentives in that way. Red flag. We keep them quite separate in terms of day-to-day operations. Lie. They were living in the same place and doing the same thing. We definitely have a Chinese wall in terms of information sharing to ensure that no one in Alameda could get customer information from FTX or anything like that. Big, big lie. Or any sort of special treatment from FTX. They really take that pretty seriously. Also, lie. Like, they take all the serious rules seriously. Such public representations by and on behalf of defendants did not reflect reality. They were lies. Throughout the relevant period, Alameda and FTX continued to share office space, first in Berkeley, then in Hong Kong and the Bahamas. They were sharing office space at every step of the company existing. They also shared key personnel. They were the same people. Technology and hardware, they were on the same system. Intellectual property and other resources, they operated under the same structure. SBF and other senior management at Alameda and FTX also had widespread access to each other's systems and accounts. In October of 2021, in January 2020, SBF and others established a separate group of operating entities operating a digital asset exchange specifically for U.S. persons. FTX US enters the chat. And were incorporated primarily in the state of Delaware. FTX US entities also held various registrations, including as a licensed money transmitter under the laws of the state of South Dakota. FTX US offered trading to US persons in large number of digital assets, including but not limited to spot digital commodities. Basically, they had to create a conduit that would allow the US market, allow US investor dollars to get from US investor hands to their digital market. They had to create a conduit, so they had to actually establish US-based operations. Make sense? Good. In October of 2021, FTX US acquired a commodity derivatives company called Ledger. Ledger, by the way, is outside of the bankruptcy. Ledger is actually doing just fine because Ledger was regulated the entire time. FTX US Derivatives, Ledger, operated as a CFTC registered designated contract market, derivatives clearing organization, and swap execution facility. Ledger maintained separate bank accounts and, upon information belief, appropriately segregated and accounted for customer funds at all relevant times. This is why the trustee is trying to sell Ledger. This is why, because Ledger is actually doing the right shit and can be sold. So yeah, Ledger doing fine. Ledger was regulated. Ledger was where they had to keep everything above board. Everything else, however, was a cluster. During the relevant period, FTX Trading purported to block US-based customers from using its exchange to transact in digital asset products, and instead direct those US customers to transact exclusively through FTX US and FTX US derivatives entities. False! Some US persons and entities were able to use FTX Trading to transact in digital assets, including digital commodity products, futures, options, swaps, and derivatives. FTX assets. FTX and Alameda commingled, mishandled, and misappropriated FTX Trading customer funds from the moment of FTX's launch. This was always a fraud. That's what this translates to. At the time Bankman-Fried and others launched FTX had the requisite bank accounts to accept and hold customer funds. Instead, customers seeking to deposit fiat currency, basically if you wanted money like this, like actual dollars, you want to use dollars in the digital exchange, you had to go through the conduit, were directed to wire their funds to bank accounts that were owned and controlled by Alameda. Red flag. Dude, if someone is a trading exchange in their exchange, they say, hey, you know what? This is how you get your money onto the exchange and you buy and invest in our assets. Here's a wholly separate entity that we're telling you is wholly separate. By the way, totally told you it's wholly separate. Go ahead and wire your money to them and they will transfer it to us. BT Dub, totally separate. Like, don't worry about it. Give your money to somebody else and they promise to give it to us. Oh yeah, no, totally separate. Yep. Some or all of those bank accounts were opened in the name of an entity called North Dimension, a Delaware registered wholly owned subsidiary of Alameda. Alameda controlled them. That on information belief deliberately did not have a name that was readily identifiable with Alameda. They deceived people to make it think it was not Alameda, which shared company space with FTX. Let me play this out for you. Basically, they acknowledge that there's a problem, that the two enterprises cannot act in Congress as one. They have to be separated. So how do they get around that? Well, here's the thing. They have this enterprise that's not supposed to be completely joined with this enterprise. They have this enterprise go over there and buy a different company that's named differently. So no one could possibly assume that they are, in fact, that enterprise. And then they use that money to funnel money to all the way here. So it can be over here. And then they can have money here. Make sense? Good. Certain of these bank accounts were located and based in the U.S. jurisdiction. Once received, FTX customers' funds were not segregated from Alameda funds or placed into the accounts designated as being for the benefit of FTX customers. They were not given a distinction. Like they were not. They were put into a big pool of money. When FTX funds were deposited into Alameda bank accounts, Alameda personally manually credited FTX customer accounts with the corresponding amount of fiat currency on FTX international ledger systems. Let me translate. Do you remember that dollar figure they were saying they were doing on a daily basis, 20 billion in trades? A certain amount of those are deposits that they have to book on both of these accounts. They have to basically trace the money as it gets deposited. They have to fund the account and show it going from boom, 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 boom. They did this crap manually. Like, so there was a person who said, okay, we have the wire transfer. Okay, I'm going to type it into this system and show that it's on this account here. Okay, I'm going to type it on the system over here in FTX, and I'm going to delete it from the system over here in Alameda. Big problem. They didn't delete it from Alameda. And other problems. Ugh. Customers accessing their FTX accounts would be able to observe on the exchange's website and later mobile application their funds had been posted to their FTX accounts, even though the funds actually remain in Alameda-controlled bank accounts. In case you have not followed along, money going in through this conduit to Alameda. They then typed on a screen that you saw that said the money went from Alameda to FTX. And that screen that you saw, that was their promise to you. They said, look, this money is now in FTX. But they didn't actually move the money. They just showed it to you on a screen. And then even on the back end in their accounts, they didn't have it documented appropriately. So basically, you were seeing smoke and mirrors, and they were playing with money behind the scenes. And by the way, the actual dollar figures remained with Alameda, who used that money to invest. So, anyone else seeing a problem here? No? No? Yeah. For a small subset of customer deposits, Alameda exchanged customer deposit funds to fiat-backed stable coins such as US Dogecoin, USDC. That's Doge? No, DC. That's USDT. DT is Tether. USDC, is that Ether? Or is that Doge? Which are generally understood to be pegged 1-to-1 and backed 1-to-1 by US dollars. Those are stable coins where they're backed by US government currencies. So basically the fictitious thing they create, the fictitious dollar, is actually backed dollar for dollar. So they said we're going to invest in this crap. I don't mean to say crap. Either way. So basically, for a small subset of deposits, Alameda would then go out, take that deposit, and exchange it for fiat-backed stablecoins, and then transfer the equivalent amount of stablecoins to FTX's digital asset wallets. So Alameda took the money, invested the money, took the coin, transferred the coin to FTX. Anyone else see kind of a problem? Money's not going like here. It's going here and then out, and then whatever's being purchased out is being transferred here. And you're being promised something that is basically saying, I'm a consumer and I invest in FTX. Alameda treated fiat currency and stablecoins as fungible. Big problem. Basically, the value of the stablecoin and currency were pegged. Like, so basically they just treated them as the same. And this was the designated method for crediting customer accounts for fiat bank deposits. Yeah, that's a problem. While this happened occasionally, customer funds typically remain solely in bank accounts in the name of Alameda. You gave them money and they made you a promise, and they said they bought this thing and it showed up over in FTX, but Alameda still had the cash. Where they continue to commingle with Alameda's own funds. Everything about this is wrong. Literally everything about this is wrong. Nothing about this is appropriate. The Alameda-owned bank accounts holding FTX customer fiat funds were collectively reflected on FTX's internal ledger system as fiat at FTX account. Dude, do better. That's your designation for that? I don't. Any CPAs in the chat want to make a comment about why that's a problem or why that suggests there might be a problem? Maybe numbers, maybe anything else, maybe something that actually makes sense. During the relevant period, this account held a balance as much as $8 billion in customer funds. This was a slush fund. That's what this is. This is a slush fund. Why is this a slush fund? By approximately August of 2020, FTX had opened its own FBO fiat bank accounts. However, FTX trading customer funds that had previously been wired to Alameda reflected in fiat at FTX group of Alameda bank accounts were not transferred to FTX's bank accounts. They promised you to transfer and they didn't transfer. Furthermore, even after August 2020, at least some FTX customers continued to send fiat deposits to Alameda-owned accounts. Consistently from the launch of FTX and throughout the relevant period, Alameda accessed and used FTX customer funds for Alameda's own operations and activities, including to fund its trading, investment, and borrowing lending activities. Slush fund. Not your shit, used for your shit. Alameda's use of FTX customer funds included both customer fiat deposits that were sent to Alameda-owned bank accounts and customer digital asset deposits and holdings that Alameda accessed via the unbounded withdrawal capabilities of its FTX trading account. Basically, Alameda continued to borrow money from FTX on the promise that they would never have to repay it to FTX. They took that borrowing from FTX, never have to repay it. They don't own that money. They borrowed it. They commingled it with your money that was actually just held in these accounts that was being reflected in FTX's balance sheets, and they went and used that and spent money on themselves. Misrepresentation related to the operations of FTX and Alameda. The use of customer funds by Alameda was not authorized by FTX customers, and FTX customers were not made aware that their funds were being used by Alameda. They didn't even know they were depositing to Alameda. Reminder, this was a separate enterprise opened under Alameda that they were depositing to. That was intentionally separate. To the contrary, FTX's terms of service expressly prohibited such use of customer funds, specifically Section 8.2.6 of FTX Trading Terms of Service. This is the promise they made to you. This is where the CFTC gets its authority. They made you a promise, an investment promise. This is what they're held to. All digital assets are held in your account on the following basis. Title to your digital assets shall at all times remain with you and shall not transfer to FTX Trading. Let's count the lies. 1, as the owner of digital assets in your account, you shall bear all risk of loss for such digital assets. Well, you did, but they put it on you. FTX Trading shall have no liability for fluctuations in the fiat currency value of digital assets held in your name. None of the digital assets in your account are the property of or shall be loaned to FTX Trading. 2, FTX Trading does not represent or treat digital assets in user's account as belonging to FTX Trading. That's lie number 3. You control the digital assets held in your account. 4, at any time subject to outages, downtime, and other applicable policies, you may withdraw your digital assets by sending them to a different blockchain address controlled by you or a third party. Lie number 5. Boom. There are 3 terms of service and 5 lies. So good odds. Way to go, guys. Defendants were aware of the need to segregate and protect customer assets. In fact, FTX developed internal policy documents relating to the protection of customer assets. For example, in an FTX DM policy document entitled, quote, Safeguarding of Assets and Digital Token Management Policy, end quote, dated August of 2021. This affiliated entity of FTX Trading indicated that, so for example, the company knew because the other parts of the company knew and said this shit. FDM has a responsibility to ensure that customer assets are appropriately safeguarded and segregated from its own funds. Really? You know that? This includes customer assets that may be held by third-party service providers, like Alameda or anybody else. FDM will ensure that, bullet point, customer assets, both fiat and virtual assets, are segregated from its own assets. Lie. Customer assets, both fiat and virtual assets, will be clearly designated and easily identifiable. Also lie. All third-party service providers are aware that customer funds do not represent property of FDM and are therefore protected from third-party creditors. Also lie. All third-party providers are aware that customer assets are held in trust. Oh, whopper. Regarding customer fiat assets, FDM will maintain customer accounts with a regulated credit, e-money, or payment institution that is acceptable to the Securities Commission of the Bahamas. They're suing you too. Customer accounts will be designated as such, and the monies contained therein will be appropriately ring-fenced and protected from claims against FDM. Lie, 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 you liar, liar, liar. Customer monies will be appropriately ring-fenced to protect from 1. The unlikely event that FDM becomes insolvent. Well, that aged well. The use of customer monies being used to benefit others. That aged just as well. And FDM using customer monies to finance its own operations. Well, that's 3 for 3. Written notice will be provided to the relevant regulated credit, e-money, or payment institution to clarify that the assets contained are held by us on trust for our customers, and they are not entitled to combine the account, any other account, or to exercise any right of set-off or counterclaim against the money in those accounts in respect to any debt owed by us. We are not allowed to use your money or credit your money or leverage your money for any debt that we owe. Lie. All customer accounts will be under the dual signatory of 2 directors, or of 1 director together with a senior member of the management team. Y'all, every single thing in there, everything in there. Throughout the relevant period, SBF and other representatives of FTX consistently and repeatedly reiterated in a variety of contexts that customer assets were properly segregated and custodied by FTX at all times, in conformance with both FTX's terms of service and generally understood best practices for derivatives exchanges, which presumes a requirement for customer disclosure and consent in order to engage in rehypothecation of customer assets, reuse of deposited assets. Such statements about the treatment and custody of customer assets include misstatements that SBF and others made or caused to be made to the U.S. Congress, the CFTC, and or other federal and state government agencies, investors, and in public venues such as Twitter. You went out and told people this stuff, and you did it using our platforms. That's what they did. They said you used Congress to sell your bullshit. You used the CFTC. You used other agencies, and you used all the venues to say this crap. For example, during February of 9th, 2022, testimony before the U.S. Senate Committee of Agriculture, Nutrition, and Forestry, senators that were likely donated to by SBF, Bankman-Fried, while advocating for the implementation of legislation regarding digital assets and the extension of certain legal protections of digital asset exchanges, testified as follows with respect to FTX's treatment of customer funds. This is SBF's statements. FTX has policies and procedures for its platforms today that reflect this basic principle by maintaining liquid assets for customer withdrawals, including a sufficient balance of digital assets funded by the company for its non-US platform, basically one-to-one backed, you're protected. The resources are funded to provide sufficient cover against user losses under certain events and extreme scenarios in order to, among other purposes, ensure a customer without losses can redeem its assets from the platform on demand. How did that age, Mr. Bankman-Fried? Like, just, how's that going for you? Really? Doing well? Yeah? Sure. In keeping with this principle, FTX provides a user experience that enables any user to easily view account balances for all assets. Account balances that you're viewing, by the way, were on a screen that might not have accurately reflected the value of your account or the assets you had or didn't have. For all of its platforms in real time, by logging into the customer account at FTX, the customer can immediately view the types of assets they own held in custody by FTX. That's suggesting they didn't use it. The assets are ledgered and easily identifiable to the user, but held in an omnibus wallet in the case of the customer's tokens in order to better promote liquidity on the platform. Pursuant to internal policies and procedures, those didn't work well, and FTX regularly reconciles customers' trading balances against cash and digital assets held by FTX. Using QuickBooks based on manual input from different transactions that trace money from one, U, to B, the bank, to C, Alameda, to D, FTX, to all other investments. Sure. Additionally, as a general principle, FTX segregates customer assets from its own assets across our platforms. Contrary to such representations and without disclosure to FTX customers, Alameda and FTX commingled funds and freely used FTX customer funds as if they were their own, including as capital to deploy in their own trading and investment activities. On information and belief, SBF, his parents, and other FTX and Alameda employees used FTX customer funds for a variety of personal expenditures, including luxury real estate purchases, $16.4 million for the parents, $121 million investments in the Bahamas, in property, private jets, documented and undocumented personal loans, and personal political donations. On information and belief, commingled funds, including FTX customer funds, were also furtively used by Bankman-Fried and FTX for extensive marketing and promotional expenses in the U.S., including a Super Bowl commercial and the sponsorship of a sports stadium in Miami. Talked about that. Many of these advertisements, including the Super Bowl commercial, touted FTX as, quote, the safest and easiest way to buy and sell crypto. These promotional activities were carried out in the U.S. to generally promote FTX rather than specifically FTX US. On information and belief, some of these promotional activities were paid for or guaranteed by FTX trading entities. Section E, Alameda's relationship with and special privileges on FTX. This is where we get into the fun stuff. From the launch of FTX, Alameda operated as a primary market maker on FTX trading. So now we're going to explain what that is. In that capacity, Alameda acted and has as an always available buyer and seller of digital assets in order to provide sufficient liquidity and an available trading counterparty to FTX customers. Starting to sense how this is working. Over time, FTX acquired additional institutional market makers, but Alameda remained a high volume market maker throughout the relevant period. Alameda also performed a number of other functions for FTX. For example, where'd that go? For example, Alameda helped FTX maintain an acceptable balance of various digital assets, particularly stablecoins, in its wallets. To do so, Alameda was authorized to make large exchanges of various stablecoins on behalf of FTX Trading, using FTX Trading's assets rather than its own. So remember, big wall between the two. Big wall between the two. Alameda is supposed to invest to back liabilities FTX has. But Alameda is leveraging assets that are owned by this one to go and make bets over here. Alameda enjoyed certain essential and undisclosed benefits and privileges on FTX. These advantages were programmed into the code for FTX trading at the direction of SBF. For one, Alameda was exempt from FTX's auto liquidation risk engine functions, which would automatically liquidate, sell a customer's open position when their maintenance margin fraction fell below a certain determined level. Basically, if you were a customer and you were investing on margin, which means you were borrowing from the exchange to make an investment in a certain stock, okay? If the investment dropped below a certain dollar figure, they required you to put money back in. If it dropped below a certain threshold, it triggered an auto liquidation, which means they would issue a call. You have to come up with the money or else you forfeit the trade. Okay? Alameda was exempt. So they could do all the shit and never have to get called for it. All customers who took on such leverage on risk on FTX would thus be auto-liquidated by the exchange. Alameda was exempt. It could not be liquidated on FTX trading under any circumstance. This exception was a hard-coded into the system, which means that it could, even if they wanted to do it, it was coded in. They could not do it. The advantage was not publicly disclosed during the relevant period. The existence of this and other advantages directly contradicted public statements made by or on behalf of defendants. It also contradicted their terms of service, which is the promise they made to customers and consumers, which is kind of why they're here. Alameda's account on FTX also had a special designation in the FTX trading code labeled as an allowed negative flag. Holy crap. Which allowed Alameda to execute a transaction even if it did not have the funds available in its account to do so. They got to trade and buy and sell when they didn't have assets to back the transaction. Are you kidding me? Like, you don't have the liquidity to do it. You don't have the money on hand. You don't have the collateral to do it. You don't have the ability to lend against anything you have on hand, but you're still allowed to go and purchase. Alameda also had an essentially unbound credit limit in the FTX database. On at least one occasion during the relevant period, Alameda had reached a previously set borrowing limit for its FTX account. In response, Sam Bankman-Fried directed FTX personnel to raise the borrowing limit to a level that would be unlikely to ever be exceeded. Let me put it this way. Alameda maxes out the credit card. And everyone else in the company is supposed to say, no, you max out the credit card, you got to pay back. SBF goes, no. Raise the credit limit. And don't just raise the credit limit by 1,000. Raise it so that we never hit that threshold again. On information and belief, FTX personnel ultimately raised Alameda's borrowing limit to be many tens of billions of dollars. Many tens of billions of dollars that Alameda could go red with no action. Literally unlimited credit card. Alameda had all the money. They had all the spending power. Every bit of financing that FTX could derive, every bit of leverage that FTX could use, their FTT, which was their own created currency to inflate the valuation for. They could basically go out on different exchanges, say FTT is worth $10 billion, and they could borrow money. And they could use that borrowing power and just give it to Alameda. Or Alameda could use the borrowing power of FTX and say, hey, I'm Alameda. I'm going to go out and make this investment for my benefit, Alameda. I'm not going to leverage my money. I'm going to leverage FTX, which backs me. FTX, which creates a dollar figure, or an FTT, which is not adjusted properly. So FTX says, I have $10 billion of value, which is fictitious, doesn't exist. Alameda then gets to go to third parties and invest and say, no, I don't have the assets, but FTX has $10 billion of value. So let me make these margin trades. Let me make the margin trades on this promise. And let me just do that. Let me go ahead and make that investment. And by the way, if I ever start falling short with regard to FTX, no worries. I can go as negative as I want to. Alameda's borrowed funds could also be withdrawn from FTX. These features in combination allowed Alameda unlimited ability to borrow and withdraw and digital assets directly from FTX trading to put towards its off-platform activities, just what I described. This functionally existed separate and apart from Alameda's more limited participation in FTX partner-to-partner margin lending program. This was wholly separate. This was a special arrangement for Alameda. Okay. Alameda's ability to withdraw unlimited funds from FTX trading was not publicly disclosed during the relevant period. On information belief, defendants were aware of and responsible for these functions throughout the relevant period. I saw a chat that I wanted to bring up. The New York Times is going to have a problem. For the kids, thank you for sending this, and thank you for engaging the chat in this regard. New York Times article says parents are sad they're going to go broke for Sam's defense. Dad also has his own lawyer. By the way, those parents were employed for a period of time by FTX. Those parents also live in a home that was purchased by FTX, a home that's worth $16.4 million. Those homes every asset that was transferred by FTX, because those funds were derived and used for fraudulent purpose, the U.S. has the ability to go and basically say, no, forfeiture. You don't get to use it. So I wonder how far the U.S. is going to go in that regard. But I think that every dollar that went out of FTX to benefit people in his known circle is going to be subject to forfeiture. So, yeah. Alameda's ability to withdraw unlimited funds from FTX trading was not publicly disclosed during the relevant period. On information and belief, defendants were aware of and responsible for these functionalities throughout the relevant period. Alameda also enjoyed order execution timing privileges for its transactions on FTX trading. Jesus. Alameda got their money out first and got to engage in real time when there was a delay for everybody else. Everybody else was delayed. Alameda got there first. See a problem there? As a result, Alameda's transaction orders were received several milliseconds faster than those of other API users. Market advantage. In the high frequency trading sector, this is a significant time advantage. Yeah, you click that button and that time is a big difference. This was not publicly disclosed during the relevant period. Dude, that's a problem by itself. On information and belief, defendants were aware of and responsible for these functionalities throughout the relevant period. They either intentionally did it or they knew it was going to happen. Alameda also enjoyed additional execution time privileges as a result of not being subject to certain automated verification processes. So basically, you would go in and make a trade and you would have to put in a two-factor authentication or something to that effect. Alameda didn't have to do that. So while you were executing a trade and verifying that you were the person you were, Alameda had the leg up. They didn't have to verify. They got to go and straight and make the transaction. Not to mention, they already had the time a couple of seconds before you did. So let's say the market is going down like crazy. Alameda sees it going down like crazy. You are sitting there typing in your second factor authentication and trying to verify the transaction. Alameda already knows the market's going down a second before you do. They don't have to verify the information, and they're able to get out ahead of the loss. See any problems? No? Maybe? Good. Oh my God. This is what I just explained. Similarly, if other customer placed several orders at one time, so if you're doing sequential orders or if you're doing multiple transactions at one time, each transaction had to be confirmed as it was done. Alameda didn't have to do that. Alameda would batch trade, and while you were verifying each transaction, what's my code? What's my password? Verify. Alameda was just like, hey, process all this shit. These advantages were not publicly disclosed during the relevant period. On information belief, defendants were aware of and responsible for these functionalities throughout the relevant period. Defendants were aware of and participated in facilitating the foregoing privileges afforded to Alameda, both with respect to Alameda's advantages on FTX, with respect to Alameda's ability to misappropriate FTX customer funds. I told you this part was good. Remember that whole wall that existed between Alameda and FTX that just didn't really exist, but we kind of were supposed to pretend it existed? And the commingling of funds and Alameda getting an automatic advantage compared to everybody else that was invested on the exchange? See how this is a problem? See why this is being called embezzlement? At the direction and under control of SBF, Alameda used large amounts of capital, including capital derived from FTX customer funds, described that earlier, to undertake significant illiquid investments and transactions. They borrowed in the red. They invested in the red. They short sold a lot of shit. And they bet wrong, including long-term equity holdings of a variety of digital asset companies and large acquisitions of relatively illiquid digital assets. Basically, they went up and bought up all of the effed up other assets. Why? Well, a lot of those assets and a lot of those companies were under investigation. For doing shady shit. One of Alameda's most significant holdings was the FTT digital asset. There we are. There's the fictitious dollar. Here we are. Fictitious dollar. FTT was the FTX exchange token and could be used to obtain discounted trading fees for transactions for FTX trading. Oh, On information belief, Alameda did not pay to acquire its FTT holdings. So that money that was created by FTX, it just gave it to Alameda. Sure, that doesn't undervalue the currency. So when they dropped, like when Sam Bankman-Fried was testifying, the money dropped in value 50%. Maybe it's because Alameda was holding a lot of it that they never paid for or had any money to back up. FTX consistently used 1/3 of its trading revenues it collected to buy FTT tokens in the marketplace and, quote, burn them, a mechanism to permanently take the tokens out of circulation by sending them to a smart wallet from which they could never be withdrawn. On a weekly basis, FTX Trading announced on Twitter the quantity of FTT it had bought and burned that week. This was basically trying to keep the value of FTT up. The more you liquidate of that token, the less token there is, the higher you can keep the value of the token because the quantity is down. Basically, reverse inflation. On information belief, this was intended to raise the value of FTT tokens that remain in circulation and thereby the value of FTT that Alameda held. Value that they didn't pay for, by the way. Alameda's FTT holdings were a significant portion of its balance sheet and a significant portion of all FTT in circulation. Alameda had all the FTT. Alameda valued its FTT holdings on its balance sheet at the market price at which FTT was traded. Without applying the discount to reflect it could not have sold its significant FTT holdings into the marketplace without causing sharp reduction in trading price. If you are a company and you create a token and you start offloading that token, the value of that token starts going down because it's like, wait, why are they offloading their token? Not only that, but the whole Alameda valuing its FTT holdings at the market price in which FTT was traded was exclusive to FTX. So FTX was the exchange where this was traded, which means it really didn't have a market price. These smoke and mirrors. Like, this is magician shit. Alameda also held extremely large quantities of several other illiquid digital assets relative to their circulation volumes, and likewise did not apply a discount to the value of those holdings on its balance sheet. If you're holding things that are not liquid, you have to reflect they're not liquid and not available to meet certain demands. That is why they should be valued less than if they are liquid. Alameda relied on significant holdings of FTT and similar illiquid tokens valued at the market value of the asset without discount as collateral to support a number of large loans from various digital asset lending platforms. That's what I was talking about before. FTX has this thing. FTT is a created dollar figure. Alameda uses the pretend dollar figure, the pretend value, to go out and borrow money. Cool, right? During the relevant period, Alameda took out a large number of loans, at times totaling as much as $10 billion in notional value during the relevant period. Misappropriation of customer funds. This is why I hope you guys are sticking along for this, because this is where it gets really all of this stuff gets really fun here. By early 2022, Alameda had invested several $1 billion in directional, unhedged, illiquid, and or long-term investments. Risky. To fund these investment activities, Alameda had relied on billions of dollars of loans from digital asset lending platforms. They borrowed money to make risky loans. Traditional bank lines of credit and its unlimited borrowing abilities on the FTX, including its access to customer funds. They used your shit to make risky loans or risky bets. In approximately spring of 2022, the digital asset markets as a whole experienced a significant downturn. Yep. This downturn came to a head in May of 2022 with the crash of two significantly widely traded assets whose value crashed essentially to zero. There was significant contagion from this event, including a major decline in the value of Bitcoin, Ether, and other digital assets. So more of the stable currencies were also getting hit by this. The devaluation of such central high-volume digital assets resulted in major credit defaults. Everyone defaulted on loans throughout the digital asset industry as the value of collateral guaranteeing various loans declined. Your asset's worth less, your loan, you don't have money. As a result, a number of digital asset lenders and market participants made margin calls. Remember what we talked about before? You borrow money to make investments. That investment fails, and then you have to pay the money back, or they close on the transaction. Liquidated open positions, recalled loans, and or collapsed entirely, including into bankruptcy. Basically, things start crumbling. In approximately May or June of 2022, Alameda was subject to a large number of such margin calls and loan recalls. Alameda was being called on its shit. It did not have sufficient liquid assets to service its loans. It didn't have it. It just didn't have it because it was using FTX to borrow and make the transactions. It did not have sufficient blah, blah, blah. Instead of the direction of SBF, Alameda greatly increased its usage of FTX customer funds to meet its external debt obligations. Do you see the problem there? It was already using FTX customer funds, which it promised not to do, which is already a problem. And then when things started going south and their investments started tanking, other lenders weren't falling for the bullshit of, by the way, we don't believe that FTT is valued the way it is. You got to start paying us the money. In order to get the money, Alameda dipped into the honeypot and took customer money. Alameda was able to rely on its undisclosed ordinary course access to FTX credit and customer funds to facilitate these large withdrawals. They took your money to pay their debts. That's what that is, which were several $billion in notional value. Defendants were aware of and responsible for this misappropriation of FTX customer funds. You guys have heard everyone asking, where'd the money go? Where'd the money go? Where'd the money go? This. That's where the money went. This crap. Money's not there because it was paid elsewhere. Oh, Lordy. And I'll pull that up in a second. Thank you to those of you who sent me that video of Sam being escorted from the courtroom. I'll pull that up in 1 second. By approximately mid-2022, the FTX's internal ledgers reflected the balance of Alameda's fiat liability to FTX totaled approximately $8 billion. So all of a sudden they had the book and they had to show they had $8 million liability to FTX. Now you're starting to see how this value crashed. Publicly during this time, defendants portrayed that they remained highly profitable and liquid. Following the market crash of May 2022, Bankman-Fried, through Alameda and other entities, bailed out several digital asset companies with loans or acquisitions. Bankman-Fried portrayed those activities as being benevolent and for the benefit of the digital asset industry. Basically, here's what he did. He took money, bailed out these failing companies to prevent their failure, because preventing their failure kept his company alive. And he went out and did, I'm trying to create stability. No, you're trying to stave off the eventual collapse of your own enterprise. In connection with the acquisition of one such digital asset lending platform from a bankruptcy sale, Bankman-Fried tweeted, "Our bids are generally determined by fair market price, no discounts. Goal isn't to make money buying assets at cents on the dollar. It's to pay one on the one and get the one back to customers." How well did that age? Oh, this person. All right. I'm going to play this and then I need 2-second break. Stop that screen. Present this screen. Share screen. Here we go. All right. Give me 2 seconds. Enjoy that clip.
Anything you'd like to say? Anything you'd like to say? Anything you'd like to say? Anything you'd like to say?
All right. So have we enjoyed watching that? It's nice to see he wore a suit. Yes, it was looped. Yes.
Anything you'd like to say?
That's him wearing a suit. He wore a suit. Good for him. He wore a suit. And let me close that out. Thank you to those who sent that to me. Very much appreciated. I very much enjoyed watching that. Back to the action. On information relief, SBF stated privately that he was pursuing aggressive acquisition strategy during this time, at least in part to gain access to additional sources of capital that could be used to support his existing businesses and fill the hole in customer funds that needed to be created. He ran out of money and needed money because he spent the money. SBF acknowledged this large outstanding imbalance to a small group of key personnel at FTX and Alameda through the relevant period. In one such conversation, now we get to DMs. In one such conversation, Bankman-Fried indicated to an FTX executive that he was not concerned with Alameda's liability on FTX because it was sufficiently collateralized by Alameda's holdings of FTT tokens, the same tokens whose market price Alameda's trading desk was actively trying to control. So let me translate. Sam Bankman-Fried is saying, don't worry, Alameda is protected because they have FTT. Meanwhile, Alameda is saying FTT is worth this. Good job. At least in part to remediate the risk of Alameda's large liability would be discovered. At SBF's direction, FTX executives relocated Alameda's approximately $8 billion in liabilities to a customer account on FTX's systems that SBF would later refer to as our Korean friends account or the weird Korean account. Holy shit. Oh, you cannot make this crap up. I'm sorry. Oh my God. He literally took Alameda's liability and transferred it and said it's our Korean friends account and or the weird Korean account. That was what he called it. It was not opened under an Alameda research identifier and was not otherwise readily identifiable as being an Alameda associated account. No one could identify this thing other than the fact that it was called the weird Korean account. The weird Korean account. You operate an exchange that's worth how many billions of dollars and you have an account that's called the weird Korean account? The system notes associated with the account described it as FTX fiat old. Can't account for it. As a result, it was no longer apparent on FTX's ledgers that Alameda had an $8 billion negative balance on its FTX account. Holy crap. Holy crap. The same type of allow negative flag and an exemption from liquidation characteristics were applied to so-called Korean account, as was applicable to the Alameda main account and other sub-accounts. Contemplated shutdown of Alameda. Here you go. Now we get to the like fraud. It was like light fraud before. It was structural fraud before. Now we get to like the real person doing the bad things. In or around September of 2022, Bankman-Fried drafted and shared a document that questioned whether Alameda should be permanently shut down. The document titled, quote, "We came, we saw, we researched." It began, quote, "I only started thinking about this today and so haven't vetted it yet, but I think it might be time for Alameda Research to shut down. Honestly, it was probably time to do that a year ago," end quote. SBF went on to lay out a number of reasons for the suggestion to shut down Alameda, including, quote, "the fact that we didn't hedge as much as we should have. A loan cost more in EV, expected value, than all money Alameda has ever made or will ever make. In the current environment, capital is really expensive, and Alameda doesn't justify it. And Alameda is making some money trading, but not enough to justify its existence," end quote. These admissions were directly contrary to contemporaneous public statements that Bankman-Fried and Alameda were making regarding Alameda's profitability. "We're making tons and tons of money. The company is doing wonderful. There are no problems here. We are failing terribly. We need to shut this down." Yep, that'll get you in trouble. SBF also laid out a number of large downsides to shutting down Alameda, including those that reflected the interconnectedness between Alameda and FTX trading operations, such as, quote, "less liquidity on FTX," end quote, and the observation that, quote, "given the amount that Alameda is doing, we can't really shut it down." Bankman-Fried also drafted a contemplated Twitter thread to announce the shutdown of Alameda and concluded, quote, "I feel really uncertain what's right, so I guess my plan is that this coming weekend we should just make a call and enact it before next Monday one way or another. Thoughts? Question mark." You guys remember in his testimony how he was so focused on passwords and emails and communications? And I said, well, you no longer run the company. You're no longer a CEO. They're property of the company. Yeah. Yeah. Mm-hmm. Mm-hmm. Anyone else want to tell me that he had any customer interest in mind in that testimony after reading this in combination with the testimony itself? I need my passwords. I don't have the data. I need the data. John Ray is keeping the data from me. Also, the data. I was doing terrible fraudulent things. Okay. And when the lawyers were telling him to file Chapter 11 bankruptcy, here's the funny thing. Lawyers operate based on information and disclosure. Oh my God, information disclosure. That's what lawyers do. Information disclosure. We have to have information. If I know that you have done the fraud things and you have text messages admitting the fraud things, I'm not going to advise you to do something that admits to the fraud things. But if you don't tell me about the fraud things, I'm going to tell you to file Chapter 11 because in my mind, you haven't told me about the fraud things. So how am I supposed to know that when you file Chapter 11, someone's going to discover the fraud things? I mean, this is the fraudiest fraud that frauded. Are there more words for fraud? On November 2nd, 2022, the online digital asset news publication CoinDesk.com published an article titled "Divisions in Sam Bankman-Fried's Crypto Empire Blur" on his trading titan Alameda's balance sheet. People were discovering what was going on. And titled, "Alameda had 14.6 billion of assets as of June 30th. According to a private document CoinDesk reviewed, much of it is the FTT token issued by FTX, another Bankman-Fried company. People are discovering that there's no longer a wall, that it never really existed in the first place." This article reported on a purported leaked Alameda balance sheet that showed that at least as of June 30th, 2022, an extremely high portion of Alameda's $14.6 billion in assets consisted of FTT token, made up value. On November 6th of 2022, in response to this article, the CEO of Binance tweeted that, quote, "Due to recent revelations that came to light, he would be selling the remainder of his significant FTT holdings, which he acquired during the buyout of FTX seed investment." He found out the shit. Like he found out the problem. He found out the problem and he went and he said, "Sell." No. He said, "No, I see the problem," and then ran. In consultation with Bankman-Fried and others, the CEO of Alameda responded on Twitter that Alameda would be willing to buy back all of Binance and Zhao's FTT holdings at $22 per token. Okay. At the direction of Bankman-Fried and the Alameda CEO, Caroline Ellison, FTX personnel began liquidating Alameda's investments and trade positions to rapidly free up capital for FTT buybacks. Nevertheless, the market value of FTT steadily declined. They tried to create money out of a thing that didn't have money and didn't exist. On the evening of November 6th, as they monitored and reacted to the movements in FTT prices and contagion effects on the digital asset market more broadly, Bankman-Fried and Alameda executive expressed surprise that these events had not had a larger negative impact on the prices of Bitcoin, saying in a chat message, "Oh, yeah, when you file Chapter 11 bankruptcy, the company has your shit. They have your information. You don't own it anymore." Former Alameda executive number one, quote, "I'm surprised Bitcoin isn't down more." Another person, "Me too." Bankman-Fried, "Yeah, me three." At this time, Bitcoin market prices, including on U.S. exchanges, had indeed begun to decline, likely as a direct or indirect result of the events described herein. At the same time, an increasing number of FTX customers began requesting to withdraw their funds from the exchange. "We see Bitcoin going down. I want my money back." FTX personnel initially managed to keep FTX systems operating quickly enough to keep up with the withdrawals, but soon fell behind. By late in the day on November 7th, reminder, November 7th is when he went out and said, "Nothing is wrong." It was apparent to defendants that FTX did not have sufficient funds to cover all customer withdrawals, and there were not sufficient funds held in various FTX accounts to cover all customer deposit obligations. You guys remember when I said that the CFTC complaint had the deets? This is the stuff. Like the charging document, okay, cool, charges. This is the dirt. This is the tea. Bankman-Fried and other key personnel at FTX and Alameda acknowledged internally that the shortfall was not merely a matter of having sufficient liquid funds on hand to cover customer withdrawals in the short term. Rather, FTX customer funds were irrevocably lost because Alameda had misappropriated them. We lost your... Yeah. And now we have to own up for it. That same day, the Alameda traders who had been liquidating Alameda's open positions to free up capital for FTT buybacks were directed to instead sell everything that could be sold quickly from Alameda's holdings to maximize open lines of credit or any other available sources of capital, and generally do anything possible to quickly obtain billions of dollars in capital and send to FTX. Reminder, Alameda had FTT, and when you start selling that shit off, oh my God. Bankman-Fried reinforced the instruction, confirmed a trader's summation of the directive as, and this is Bankman-Fried, quote, close everything down to generate capital, maximally aggressive to liquidate all positions. Bankman-Fried responded that, quote, there is definitely a fair bit of urgency, end quote, and asked for, quote, an ETA on getting at least $2 billion by US dollars, end quote. I need $2 billion stat. No problem. No biggie. I need $2 billion stat. But Sam, I thought $8 billion was coming straight through the door, and we're supposed to trust you. Surprise, surprise. On or about November 7th, FTX executive were also asked to evaluate the solvency of FTX US. They were readily able to carry out this request because FTX personnel had access to and oversight of the FTX US, but not FTX US derivatives code, database, and ledgers in the ordinary course of their duties. FTX US derivatives was the bank account that they were funneling money into, so they could see the FTX, but they couldn't see the bank account that Alameda was using. Cool. FTX executives ultimately identified a shortfall they did not understand and were unable to quantify on FTX US because the balance sheet didn't fucking match because you moved shit around. Bankman-Fried quickly indicated that he would fill the hole at FTX US from liquidation of Alameda assets. Oh, God. On November 8th, Bankman-Fried directed Alameda traders to prioritize meeting FTX US capital requirements and to send excess capital to FTX US. I thought there was a wall between the two. I thought they didn't exist. I thought Alameda had unlimited credit card. On information and belief, Alameda sent in excess of $185 million FTX US to fill this shortfall. Later that same day, on November 8th, an Alameda executive indicated in a chat message that apparently part of what's going on is that Alameda actually has a long USDT short USD margin position on FTX US that we aren't tracking, which is why FTX US has less than we thought it should. Basically, there's a liability that's off the books that should be on the books, and that's why we can't make money. The direct contradiction of this internal series of events on November 7th in public statements and various Twitter messages, here we go. Bankman-Fried and others acted on behalf of FTX continued to portray the shortfall that was causing customers to be unable to withdraw their funds as merely a liquidity problem. They affirmatively and falsely stated that FTX continued to be solvent and that all customer deposits were safe. For example, Bankman-Fried tweeted, and I hearken back to several weeks ago when we first read these tweets on Friday Night Frenzy, and I was going, what in the actual are you doing? Oh, SBF, a competitor is trying to go after us with false rumors. FTX is fine. Assets are fine. Don't tweet your crimes. Details. FTX has enough to cover all of client holdings. We don't invest client assets, even in treasuries. Lie. We have been processing all withdrawals and will continue to be. Also lie. Some details on withdrawal speed. Twitter tracking thing. Banks and nodes can be slow. On information belief, this and other tweets posted by Bankman-Fried on November 7th and 8th were intended to dissuade FTX customers from requesting to withdraw their funds from defendants' exchanges. Don't mind the house burning behind me. Please don't mind the house burning behind me. Everything is fine. We're all okay. No, the big flaming house back there, do not look at it. Don't look. Believe me, you have the whole time. This and other iterations of proposed tweets by Bankman-Fried were debated and rewritten among a small group of defendants, key employees, and other Bankman-Fried confidants. On information and belief, several individuals expressed concerns that Bankman-Fried's tweet was inaccurate and or misleading. Gee, I wonder why that was. At the same time as Bankman-Fried was making these public assurances, he and numerous others acting on behalf of FTX Trading were also reaching out to as many sources of funding as possible in an attempt to quickly raise several $1 billion to cover the shortfall in customer funds. As their calculation of the amount of shortfall grew from 1 to 2 billion to 2 to 4 billion to as much as 8 billion, dude, imagine that accountant. Like he's sitting there going, we have a 1 billion liability. 2 minutes later, nope, I meant 2 billion. 3 minutes later, nope, I mean 3 billion. 10 minutes later, boss, it's probably 8 billion. Yep. The number of viable potential rescue options diminished. Numerous parties declined to bail out FTX regardless of their favorable terms being offered because they saw your balance sheets. They knew you were just, oh my God. I've been fucking saying this from the very beginning. I have been saying this from the beginning. I have been saying that I wanted to watch this. I've been saying all of these things. None of this made sense. Everything that was being said should never have been said publicly. All of this was falling in and it was going to come to a collapse. Every single thing. And I think I also said when Bankman-Fried was going out that the Department of Justice has just entered the chat. I think I was basically saying all of this crap. And you know what? The Department of Justice was listening. And they were like, hey, by the way, you know, we were listening. At approximately this same time, Bankman-Fried prepared or caused to be prepared a balance sheet to be shared with prospective investors showing the assets and liabilities of the company. Oh, and this just gets even better because I am so glad we read that testimony. Remember that balance sheet he was going to show Congress? The one today, the one that was in his testimony that said, don't worry, 8 billion, we have it. The balance sheet was unorthodox in a number of respects. Most notably, the balance sheet included an 8 billion negative balance from a, quote, hidden, poorly internally labeled, quote, fiat account. On information belief, the fiat account was in fact well known and understood by Bankman-Fried, who had previously directly managed and directed its use and characterization on the FTX system. On November 8th, Bankman-Fried called the CEO of Binance to offer to sell FTX to him in its entirety. And now you can see why he said nope. Binance initially accepted the offer to announce the news on Twitter saying, this afternoon FTX asked for our help. There's significant liquidity crunch to protect users. We signed a non-binding letter of intent intended to fully acquire FTX.com and help cover liquidity crunch. We will be conducting a full DD due diligence in the coming days. Defendants thereafter provided Binance with various information in response to their due diligence inquiries in furtherance of the letter of intent. We promise to buy this if your numbers match up with what you give us. In narrator voice, and the numbers did not match up. On the morning of November 9th at approximately 10 a.m., after the announcement of the Binance acquisition, the CEO of Alameda held an all-hands meeting with Alameda staff. In that meeting, the CEO stated that earlier that year, in response to an accounting or bookkeeping problem, Bankman-Fried and other individuals had decided to use FTX customer funds for Alameda. The CEO indicated that FTX had always allowed Alameda to borrow customer funds and that FTX did not require collateral from Alameda, though in practice the collateral was Alameda's FTT. Shortly after this meeting, most of Alameda's staff resigned. Alameda goes, no, the ship is sinking. The ship is totally sinking. It's just, everything's bad. And everyone leaves. On November 9th, Just one day after announcing the deal, Binance announced it would not be able to move forward with the deal to acquire FTX, saying, as a result of corporate due diligence, as well as the latest news reports regarding mishandling customer funds and alleged U.S. agency investigations, we have decided that we will not pursue the potential acquisition of FTX.com. Surprise, surprise. With the prospects of acquisition or bailout investments being unlikely, executives of defendant entities and FTX US began advocating strongly for Bankman-Fried to move the company towards bankruptcies and halt all remaining customer withdrawals from the platforms. Stop the bleeding. Stop the bleeding. On November 10th, FTX and FTX US halted all trading and withdrawals, and Bankman-Fried announced that Alameda was being wound down. Bankman-Fried also posted a lengthy Twitter thread purporting to explain how he... Oh, no. No. Did it break? No. Live. Oh, it died. Bankman-Fried, how he effed up. On November 10th at approximately 4 a.m., Bankman-Fried signed a document resigning his position as CEO of FTX Trading and as majority owner of all FTX Trading and Alameda companies. Oh, no. Authorizing the appointment of an independent CEO and the filing of Chapter 11. These are the bankruptcy stuff that I've covered before. I've never seen anything so bad. This is really bad. This is terrible. In the days and weeks since Bankman-Fried resigned from the companies, he has continued to make widespread public statements. Again, I've talked about these. Provide explanations and make admissions, including in live interviews. Several of his statements admit key facts pled herein. For example, in a November 15th chat message interview with a Vox publication reporter, which Bankman-Fried has confirmed and participated in, he characterized the course of relevant events as follows. Like, oh, FTX doesn't have a bank account. I guess people can wire to Alameda's to get money on FTX. 3 years later, oh, fuck. It looks like people wired $8 billion to Alameda. And oh, God, we basically forgot about that stub account that corresponded to that so that we never delivered to FTX. Dude, stop. This is why everyone said, like, no, you weren't listening to your attorneys. You weren't. Because you literally just admitted that money was at Alameda. Alameda used it. Oh, we just forgot about it. We forgot Alameda owed us that money. Impact of these events on digital commodity futures markets. The foregoing series of events had a significant observable negative impact on digital commodity markets. For example, between the release of November 2nd CoinDesk article and the November 9th announcement that Binance declined to acquire FTX Trading, the price of Bitcoin futures fell more than 23% to two-year low prices. Basically, market did not like this. 10% share, remember? Good. Blah, blah, blah. Defendants caused all this stuff. The chart is a visualization of price movements. Ooh, that's a fun chart. Look at that. That's price movements. So when we're trying to describe whether this had any impact on the market, like that's like a just the following chart is a visualization of the impact of various of the foregoing market events on Bitcoin futures prices in the U.S. So Bitcoin being one of the most stable coins out there, CME Exchange with several of the key foregoing events identified on the price and timeline. On information and belief, the significant price movement demonstrated in this chart is a result of the conduct described herein. Ooh, that's Bitcoin. That's Bitcoin. And look, we have details. Announcement that CZ tweets that they're going to bail out FTX. Little spike. All of a sudden, FTX halt withdrawals. Whoop, we're down here. Then we've got the tweet that FTX is fine. Little tiny little bump. Then Binance no longer doing anything to protect them. Problem. FTX suspends trading. Tweets that he filed bankruptcy, which actually makes sense. People would like respond positive to that. Yeah. Following chart is a visualization of the impact on various of the foregoing market events on the futures price on the US CME exchange. There's Ethereum. Same thingy. Oh, baby. So, violations of all the things. During the relevant period, defendants intentionally or recklessly, in connection with contracts of sale of commodities in interstate commerce, directly or indirectly used or employed or attempted to use or employ a scheme or artifice to defraud and or engage in practices or a course of business that operated or would operate as a fraud or deceit on customers of FTX trading. They did the fraud thingies. As a result, violated the act. They're liable for the actions. SBF did this by controlling FTX and Alameda, did not act in good faith, did it knowingly. All the allegations. Therefore, pursuant to 7 U.S. Code Section 2A1B and 17 Code of Federal Regulations, Section 1.2, 2021, FTX Trading and or Alameda are liable as principals of each act, omission, or failure of Bankman-Fried and the other officers, employees, or agents acting for FTX Trading and or Alameda constituting violations. Each and every use, blah, 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 fraudulent misstatements. You guys, we read it all. Fraudulent misstatements. They said the things, they convinced you to invest. There you go. Relief requested. Here's what the government is asking for. Here's what CFTC is asking for. An order finding that defendant Samuel Bankman-Fried, FTX Trading, doing business as FTX.com, and Alameda Research collectively and through their officers, employees, and agents violated Section 6 of the Act. Okay, so they violated it. An order permanently enjoining and prohibiting the defendants and any other person associated with them from ever engaging in the type of conduct above. Sure. An order permanently enjoining the defendants from directly or indirectly trading, so you can never trade again. You can't be involved in any transaction involving commodity interests, so you can't do any of the stuff. Having any commodity interests or digital assets that are commodities, so you can't have anything traded on your behalf. You can't direct or control anyone trading or directing on behalf of anybody else. You can't solicit or accept money for the purpose of investing it. You can't apply for registration, for exemption from any registration, or engage in any activity requiring registration from the commission. You can't act as a principal or any other officer or agent with any other company that is allowed to do the things. That the defendants be directed to disgorge. Disgorge means to give up. You surrender to any officer appointed or directed by the court all benefits received, including but not limited to trading profits. So all the money you made, every bit of revenue, all the salaries, all the loans, all the fees, all the money, you have to give that up, and you have to pay pre and post judgment interest on that amount. All the money. An order directing defendants to rescind to all the procedures, contracts, agreements, every promise you made to all the people, from people or anyone who received money. Make full restitution for each and every customer who will receive or utilized in the violation of this act. That's never going to happen. Directing defendants to pay civil monetary penalties. Got to pay all the money. Pay all costs. All other things as is appropriate and proper. Here's what the government is doing. And I just want to scan this real quick because I want to make sure. I want to see if there's a part that because we're getting there, man. Like we are. It's the office space, violations. That was that one. This is the SEC complaint. There's a part that I kind of was wondering if they had it in here. Off platform, spot margin trading, same stuff, same allegations. 8 million, 420 million. That's a 300 million. We talked about that. All the frauds. I might take a look at the SEC one on Friday. How about that? But I want to double check because I feel like there was something in here that I wanted to see. Liquidation exemption. Talked about that. Repayment, line of credit. Yep. Talked about that. That's the fiat. Yep. Title is yours. All the lies, all the frauds. Then there was the promises that were not true. Yep. Material misrepresentations. Talked about that. Didn't segregate. Yep. Lied to investors. Made promises. Then we've got the remarks to the House. Covered those. Then we've got the acknowledgement of interview on December 1st. Oh, these are some of the more interviews. We've talked about those before. Then we've got the FTT token. Sure. Yep. Talked about that. Talked about the things, the large position. Didn't tell investors. Transferred money. Made all the lies. Took all the money. Money to BlockFi. I think we're going to talk about this on Friday. Let's do that. We're going to talk about the SEC complaint on Friday because we've been going for 3.5 hours, and I knew that we would because that CFTC complaint was all the details. And holy smokes, like just wow. But there was something in here that I did want to see if I could find. That was customer confidence. Wasn't there one in here that was called the fraud? Fraud, the officer's sales. Number of players or talks with of all letters intent. Yes, I made all the lies. I did all the protections. I did all the terrible things. Okay. We're going to catch up on that on Friday Night Frenzy. Because you know what? That was freaking wild. So let's hit super chats and we'll get out of here. So, y'all, all the things. So right now we're awaiting extradition. Bond has been denied. So he's still in custody. Not allowed to leave custody. Bond is still denied. Let's go through this. Between Pam Marshall, thank you very much. Between this guy and Tom Girardi, I've done so much screaming as a CPA, I have no voice left. It's insane. Same. As a bankruptcy attorney, I expected this to be somewhat like organized. It was not. Sarah Lee, thank you for the super chat. What are the steps one should go through to research a financial advisor? Websites to search. Sorry for all the questions. Just want people to be informed. I honestly am not the appropriate person to ask for those questions. I would strongly suggest you talk to someone in finance, talk to a friend that knows people in finance. I am not going to advise you how to select someone because that's not my expertise. So I'm sorry that's not an answer, but I don't feel comfortable doing that. I can tell you how to do the law things. Yeah. For the kids, if he goes to trial, would this be a jury trial? You saw the jury demand. That's in there. The Lauren, thank you very much. Can you explain why Ray was in front of Congress? John J. Ray was appointed as CEO of FTX and all the related entities. He was in front of Congress because Congress basically said, we want you to testify to all the things that are going on. What would have happened today that would have been really interesting to see is you would have seen Sam Bankman-Fried testify based on that prior written statement that we read through, the piece of trash that was the hot piling heap of garbage, I think I described it on Twitter. And you guys saw what I was talking about. We walked through it. That was horrible. So Sam Bankman-Fried would have testified to that. Then John Ray would have gotten up and just destroyed everything that he said. So that's what would have happened. But John Ray was testifying to the liquidation, everything he's discovered in the time since. Admittedly, there's not a whole lot because he's still doing a lot of investigation because as you probably saw, there's a lot of transactions to go through. So yeah, that was why John Ray was there. New Zealand Butterfly Girl, Heather. Is Mama Morton still staying with you? She's at my sister's right now. My sister gave birth 2 weeks ago to my new niece, Kate. So she's out with my sister a couple hours away. I can only imagine what she's thinking, hearing that screaming unicorn so much during the live stream. You know, she likes the streaming. She laughs. So 9 Inch Nails Gal, 1994. Got to pick up the 5-year-old half school day. So marking my place for replay. Catch y'all tomorrow for TOTC Live. We will be live on Scott Cardinal's channel for Trials of the Century tomorrow. That is right. That is 8 p.m. tomorrow. So you get 3 days in a row of live streaming. So see you then. Heather, thank you very much. They mentioned SBS parents using funds for personal use as well. Do you think they will be arrested? I don't know. U.S. Attorney General or the U.S. Attorney's office has suggested there are more charges forthcoming. I imagine they're still trying to look into what they can get charged. Those indictments do not move fast. People that were asking for him to be indicted, this is one of the fastest indictments I've ever seen. You saw Girardi, you saw Enron, you saw all of those other cases, you saw Elizabeth Holmes. It took years to get indictments. And even in Girardi's case, there still was an indictment. You have an indictment that is within a month of all of this taking place. Within a month, 30 days. That's fast. So I imagine there's going to be more coming. We'll just have to keep an eye on it. Silver Gypsy Lady, thank you very much. Is that Sparkle Fart Scream or a misdirected fart? I think that's Sparkle Fart Scream. Travel Hound, I'm back and I'm angry. How do you have a property and title registered in your name and claim you have no idea? I want Joey and Barb investigated. Well, the whole laughing in the court proceeding when the allegation was made that their son might be a fugitive. I mean, I'm not very pleased, personally. $16.4 million house, and you say that I have no clue how it's there. What's worse is the only statement they made publicly is that they've been trying to transfer it back to FTX for some time. Sure, I believe that. It's listed as a vacation home on the property records. So totally believe that they intended to transfer it back. But yeah, Victor Mom 7777. Victor Man, thank you. Tweeted video of SBF being escorted out. Yes, I got that. Someone flagged that for me. Thank you very much, Victor. Very much appreciated. Thank you for doing that. Digital coins from Suso. Digital coins are the only real crypto. With centralized coins, that this can/will always happen. I'm not going to give crypto advice. And if you see anyone in the comments doing it, and I'm going to tell you, if anyone in the comments is giving crypto advice, that comment will be deleted in any one of these comments. So no crypto advice will be given on this channel. No financial advice will be given on the channel or in the comment section. I know that there's going to be a flood of people in the comments here, and there's probably going to be impersonator accounts. Reminder, I will never ask or try to sell you investment advice. It's not me. If someone's doing it, it ain't me. Please refrain from doing that. The comments will be deleted because I'm not walking through that liability. We saw what happened to SBF. I'm not going to be SBF. For the kids, thank you very much for the generous super chat. Rob, my friend used a crypto platform known as Voyager that went bankrupt. FTX was buying them and sent a letter saying you need to agree on this buy, and then FTX went bankrupt. So she got a whoops, our bad letter. Dude, this thing is not going. It's not going away, and it's not insignificant. You saw what happened to the entire market. To suggest that crypto is just not a thing, but then you see the market respond like that to something like this, that's huge. This is a problem. Chrissy Lee, thank you very much. Please don't break yourself. I'm not. We're good. We're good. Just a little bit of venting. That's fair. That's fine. That's healthy. 70 Coker, does forfeiture of assets help with paying back debtors in bankruptcy or just a punishment from the government? The government seizes it subject to, and they can do it subject to taxing authority and to make it available for restitution. The problem that you're going to see, and they did this at Enron too, is the government seizes it and the government basically says, we're going to secure all of this property and we're also going to take our claims out of the top. Which is why the Enron debtors or Enron creditors didn't receive like hardly anything. And this is one of the big problems with this. And this is why these things need to be stopped in advance, because once the end of the day comes, the line of creditors from the most powerful being the government enterprises and the government institutions down to the least powerful, meaning regular citizens. It's a pecking order. And the people at the top of the food chain, the government, those lovely Congress people that were blowhard talking and blabbing, they get their money off the top. So that's also why I get frustrated when I read this kind of stuff. That's why I get frustrated when Congress gets out in grandstands, because they say, we were going to do things and we need to do things. You should have done the things. If you really cared about the American people, you would have done the things. So, and that goes for the Department of Justice. That goes for U.S. Attorney's Office, everybody. Bankman-Fried could have been prosecuted under each one of these laws that he is currently being prosecuted on. They didn't write new laws to prosecute him. They were there. Why didn't they step in earlier? Travel Hound, thank you very much. Indictments go quicker when you shoot your mouth off on Twitter. I said it. Oh, I'm so happy I said it. I said you play the fuck around game long enough, you're going to get the find out part real quick. That was pretty quick. Kristen M96, wait, you are just casually mentioning the new niece. No, this is wonderful. Congrats to Rob's sister and family. Thank you, Kristen M96. She was born, she was a little bit small when she was born. 5 pounds, 9 ounces. Love my new niece. Haven't met her yet because she's small when she was born. So we're letting her grow, get a little healthier, but mom's out there visiting. Nisa Howard, thank you very much. Rob sent you a link on Twitter for a new unicorn. Oh my. There's actually one downstairs. Like you all saw Mike. So I have 3 of these. 3. And this one's not fully broken. I'll just fix it. New Zealand Butterfly Girl, Heather, congratulations on the new niece. Personally, I'd like to put my money in chocolate coins. They are delicious. Yep, fair. Suso, you do not have to apologize. There is nothing wrong about that. I have no problem with you engaging. You have given great commentary and great contributions to the chat and engagement. Only thing I'm saying is that I can't give you that advice. I would say talk to your financial planner. Talk to people who know these things. I don't pretend to know these things. I know the law behind them. I know the basic structure. And we're focused on the law, and I'm trying to explain it in a way that's digestible. And the CFTC did a pretty good job with all the receipts on this one. So thank you very much, Suso. You did not have to apologize. Thank you very much for being here and for participating this evening. You guys, thank you very much. We're here 3.5 hours. It's not 4 hours. It's 3.5 hours. For everyone that showed up, thank you very much. I very much appreciate it. As a reminder, on your way out, please hit like. If you do like the channel content, hit subscribe. Also, take a look at Cracking the Box. Young Captain Corey, let's give him 200,000. Also, if you don't mind just going over, hang on. I'm seeing something real quick. I want to make sure I've got everything. I do want to say, okay, we've got that. Sorry, just want to make sure I've got everything because there was something on the back end that actually, yeah. So as a reminder, Cracking the Box, please go check it out. Very much, if you wouldn't mind, just let's try to give them 200,000. And then if you also don't mind, let's go ahead and Moffat on money. So check that channel out as well. I will put the link in the description below. I'll put the link to Captain Corey's in below and as well as Mr. Moffat. Because like I said, fantastic explanation. Love it. All the great stuff. So until next time, / until tomorrow, Trials of the Century. See you guys then. But see you then. Bye.